We will resume with questions on commissioners' questions for this panel. Let me see who has questions for the panel based on commissioners' questions. All right, why don't we do this? Ms. Kress, do you have questions beyond the information you seek to introduce? The confidential information?
I do, just a few.
Okay, so I think let's do CCBA first, then SIGFR, then Walmart, then public staff. Anyone else on this side of the room have questions? Okay. Ms. Force, questions? Okay, because I was gonna I remember your hand from yesterday, and so you would go first if you had questions. Okay. Okay. All right, and then obviously you all will get an opportunity as well. Okay, go ahead, Mr. Burns.
Thank you, Chair Mitchell. Good morning, gentlemen. I have the honor of going first to talk to you, and I have a few questions on what the commissioners covered yesterday, and I'll tell you in advance, there's two real topics. So once we get through the second one, I'll pass it off to Ms. Kress. Commissioner Brown-Bland asked you at the beginning of the commissioners panel yesterday if you had any reaction to Mr. Norris's testimony about the company having lumped various storage technologies together and not evaluated them separately, and how that affected the value of various technologies. Do you recall that question?
I do.
You responded to Commissioner Brown-Bland that you wouldn't say you had lumped technologies together, that you would not call storage a mature technology, and there were risks because only 6 gigawatts in the entire United States of battery storage have been installed. Do you recall that answer?
I do.
Later, Commissioner Duffley asked you to clarify your statement that there were, quote, billions of dollars of investment that have a lot of risk attached to them that have not been spoken about in the last few weeks. Do you recall that question?
I wouldn't say that I recalled it quite that way, but I do remember saying, yes, that there are billions of dollars investment also have risks and that all technologies have risk, and we just did not focus on those.
And then Chair Mitchell asked her final question yesterday, asking if you had anything to answer any other questions that have been asked to other witnesses. Do you recall that one?
I do recall that.
You responded to both of those questions, again, testifying that the risk associated with storage was not being adequately appreciated before the panel. Do you recall that?
I do say that we spent an inordinate amount of time talking about the risk of gas technologies and a fairly limited amount of time, if any, in this 3 weeks talking about the risk of all the other technologies such as storage. Yes, I remember that.
And then in reference to storage, you stated again that it wasn't a mature technology and that there was only 6 gigawatts of storage online. You recall that?
I do recall that.
Are you familiar with the 2022 NREL report, Storage Future Study, Key Learnings for the Coming Decades, that was attached to CCBA's comments as Exhibit I?
Vaguely.
I can hand you a copy of it if you don't mind. It's already in evidence. May I approach? I'll refer to that page if you'd like to look at the copy.
And Mr. Burns, just so I've got the right citation, this is Mr. DeFelice's testimony, or this is the prior comments?
It's the prior comments filed by CCBA. It was Exhibit I to those comments.
And write that down. Thank you.
It is a 2022 report called Storage Future Study, Key Learnings for the Coming Decades.
Thank you.
Are you with me, sir?
I am with you.
Okay, great. I handed you what is turned to page 7 of the report, which is page 16 of the document as a PDF, but it's in the lower left-hand corner. It's page 7, and it's at the top of it. It says Key Learning 3. Are you with me there?
Key Learning 3. I'm sorry. Yep, I'm with you. I'm on that page. Sorry.
The ability of storage to provide firm capacity is a primary driver of cost-competitive deployment, correct?
That is correct.
Okay.
Objection. This is not relevant to commissioner questions that were asked yesterday. He is attempting to rehabilitate a witness that's no longer on the stand.
I am using a document referred to in prior testimony to establish that storage is a mature technology. That's where I'm going.
Overruled.
All right. Do you see that the NREL's authors state there under firm capacity, it's a little blue heading, firm capacity. Storage provides firm capacity, the ability to meet demand during system peak and replace conventional generators such as gas turbines. Do you see that statement?
I see that statement from NREL.
Okay. It also states that storage can provide energy time shifting. It's one of the blue headers, operating reserves and avoided transmission, and can, in the third column, quote, provide multiple services either simultaneously or at different times, often referred to as value stacking. Do you agree with those statements?
If placed properly and evaluated properly, yes, we support storage as part of our broad mix of resources that'll be part of this energy transition.
I'm glad you went there because that's where I was going. In fact, Duke counts on the continued development of battery storage in all of the portfolios presented as part of its carbon plan and the supplemental portfolios, doesn't it?
Yes.
And Duke's near-term execution plan calls for procurement of 1,600 megawatts of battery storage through 2024, correct?
Yes, it does.
And the way Duke frames it is 600 megawatts of solar plus storage and 1,000 of standalone. Is that right?
Yes.
So that's 1.6 gigawatts of battery storage in Duke's plan. About 1/3 of the total amount of battery storage you testified was distributed nationwide currently.
Yes, I said that a concentration of risk, if you had no gas and wanted to double or triple that, would be concentrating the risk. And as I said, all these technologies have both cost and benefits. And I think it's a matter of sharing the risk across a suite of technologies and not focusing on a single one. So yes, I think we did not say storage does not have promise. It just needs to be looked at, both its benefits and its risks accordingly, along with all the other technologies. But yes, I'm with you, Mr. Burns, and we think storage will play a part of the energy transition.
And the real question between Duke and interveners is really how much and by when, right?
How much, how fast, and many other aspects. What configuration, where it's sited, how to maximize the value. But yes.
But to be clear, none of Duke's portfolios would come close to achieving the carbon dioxide reductions required in House Bill 951 without the role of battery storage.
Battery plays a role, the qualifier of how close. I don't know that I've done the analysis without batteries to see how many tons of carbon that contributes. So I will say it is integral in all of the 12 portfolios, all had storage as part of those 12 portfolios.
Thank you. That's the first topic. Secondly, Commissioner Brown-Bland also asked you as a panel if you recalled witness DeFelice's testimony about double counting and depth of discharge. Mr. Klemba, I believe you responded to that one. Do you recall that?
I do.
You stated that you remembered the written testimony and that you disagreed with Dr. DeFelice. Is that right?
That's right.
You said that when you build the costs from the bottom up, you account for the depth discharge amount that you have to overbuild the battery. Do you recall that testimony?
I do.
On page 19 of his testimony, witness DeFelice quotes page 7 of Appendix K of the carbon plan. Do you have page 7 of Appendix K?
Yes.
Give us a moment.
Sure, go ahead, take your time.
I see it.
Do you see the header depth of discharge?
I do.
The cost of the battery storage assets in the carbon plan assumes that the asset is designed to include a 90% depth of discharge constraint. This means that if a battery is designed with 100 megawatt hours of usable energy, the total energy of the battery would be 111.1 megawatt hours. The depth of discharge constraint is included to reflect requirements of the original equipment manufacturer to maintain the warranty on most batteries. Did I read that correctly?
You did.
Now, does that mean that you model that battery as being purchased as a 111.1 megawatt hour battery?
The full capacity is 111 megawatt hours. So there's enough battery storage to account for 111.
So for 90% of that discharge to be 100 megawatts, is that right?
That's correct.
Now, witness DeFelice testified that original equipment manufacturers and energy storage integrators already factor in this depth of discharge constraint when pricing. Do you agree or disagree with that statement?
Oh, I'm sure it's in the pricing, yeah.
Okay. And what cost projection, well, let me restate that. Duke Energy used the Bloomberg NEF cost projections for usable kilowatt hours of battery storage, didn't it?
Not sure. The Bloomberg,
Okay.
can you ask that again?
Well,
Perhaps point me-
if the Bloomberg NEF cost assumptions were used as referenced in figure 2-4 key base assumptions of the carbon plan, if those modeled costs were the modeled costs used for storage, it already incorporates that reduction of depth of discharge, doesn't it?
We didn't use the Bloomberg costs for storage. And if you can point me to where I state that, that'd be helpful.
Sure. Leave in chapter. Look at figure 2-4 of the carbon plan. Do you have that?
Figure 2-4, is that what do you say?
Yes. Key base assumptions.
I'm getting there.
Sure.
I'm there.
Right. Key base assumptions for selectable supply side resources.
Yes, I see that.
And it drops a footnote 11, National Renewable Energy Laboratory 2021 Annual Technology Baseline. Do you see that?
I do.
The 2021 update, are you aware that it utilizes the Bloomberg NEF cost projections?
I'm not aware of that, that they used the Bloomberg, but
Okay.
that's
And witness to Felice testified that they did, but that would be an area that you don't
yeah,
know.
subject to check. I'll agree with that, sir.
All right. And if in fact those cost projections already incorporate the depth of discharge, then accounting for a larger size battery as you did and your build up from the bottom would actually count that amount twice, wouldn't it? The extra amount.
No, I mean, we're within 1% of those value of the NREL values that include the depth of discharge that's already accounted for. So I think we're fully aligned with those costs.
And I would just respond as well that we say in our direct testimony on page 192, figure 17, we show CPSA, NCSEA, and tech customers. And on batteries, we're slightly lower than tech, very close or maybe a little lower than CPSA, and NCSEA is 20% lower than the three of us. So, we are not an outlier in this case anyway on the cost of batteries. We have two of the other interveners that say they're in agreement with us, and it's one intervener that's 20% lower.
Understood. Thank you for that response. If you'll give me just one moment, Madam Chair, I think I may be complete there, but I want to check one thing. To go back to the first question from Commissioner Brown Bland, in response to that first question, you made a statement that we gave free transmission to paired storage. Do you recall that? That was in the lumping question.
Yeah, we did not increase the proxy cost of the transmission when we added SPS, solar plus storage, had the same proxy cost as standalone, such that we didn't include an incremental cost. And I think my statement was that that may very well be the case if, subject to Mr. Roberts correcting me, if you add it without charging from the grid, which we assumed in the model. But if you did charge from the grid, we would need to relook at that analysis, because you would then need to be able to deliver solar or energy to the solar facilities when the solar wasn't there, so that you could charge the battery. And we did not study that in these proxy costs that we came up with. So we didn't increase the cost of solar plus storage in our proxy transmission.
But when you said, I just wanted to clarify for the record, when you said free transmission, you didn't give free transmission to storage. It's storage and solar on a solar plus storage system use the same point of interconnection. So the transmission improvements would be the same, correct? Or the
It-
cost of transmission.
Subject to Mr. Roberts, again, it's the battery is going to change the profile of that output. And I do think there may be, and again, I'll ask Mr. Roberts to follow up with me here, but you will change the profile. There's a potential you could even have additional transmission because of the change in the profile. So for example, solar doesn't provide energy on a winter morning, but solar plus storage will. I'm not 100% sure that it was studied that way when you did the original standalone. So we did not assume an increased cost. There may be a potential that there's an increase. We didn't assume it in our modeling, and we certainly didn't assume there was a charging cost in it. So we were to the benefit of solar plus storage is my point when it comes to the ascription of transmission cost.
And my question wasn't a way of eliciting a disagreement. I just wanted to clarify the record. I appreciate your response.
Yeah.
And that's all my questions. Thank you.
Good morning, gentlemen. You heard some questions yesterday from Commissioner Hughes regarding future costs, cost assumptions, and modeling net present value revenue requirement impacts. Do you recall those questions?
I do.
As a follow-up to that question, I just want to ask whether you modeled any sensitivities or scenarios wherein future cost estimates or net present value revenue requirement impacts were constrained.
I'm not sure I understand the question. Did we model scenarios where revenue requirements were constrained?
Correct.
Is that your,
Or were they unrestrained,
they were,
unconstrained?
it's an output. We didn't say we're going to limit a PVRR at a certain point. We did not constrain whatever the PVRR was, present value revenue requirements was, it was. We did not model any scenarios where we put a cap on that.
Thank you. That's my only question, but I do, Chair Mitchell, I had discussed with Counsel for Duke before this morning's session that there's a line of questioning that would elicit confidential information. And in lieu of asking that line of questioning, I believe Counsel for Duke has agreed to stipulate that an exhibit, a confidential exhibit, be identified, marked, and entered into the record.
Duke Energy agrees with that approach if acceptable to the commission.
All right, you may proceed.
Thank you. At this time, SIGFR 2 and 3 would like to introduce and move into the record SIGFR 2 and 3 modeling panel rebuttal confidential commissioner's questions exhibit number 1.
So we'll identify the document as SIGFR 2 and 3 modeling panel rebuttal, commissioner's questions, confidential exhibit number 1.
Thank you.
Thank you, Chair Mitchell.
I did.
Bless you.
All right, Walmart, you may proceed.
Thank you, Chair Mitchell. Good morning again, gentlemen. I'll give you a second to get that exhibit. I would like to follow up on Commissioner Claude Felter's questions with respect to gas, our favorite topic. I just have, Mr. Snyder, I think these are probably questions for you, and it goes back to the discussion of the sort of 3 alternative supply scenarios. I want to try to better understand to the extent you can. I'm trying to understand timing. So yesterday, in response to questions from Mr. Claude Felter, you indicated that the completion of MVP was the company's preferred method to obtain additional natural gas supply, correct?
Yes,
And so my understanding, and please correct me if I'm wrong, because in some ways I was a little confused. Once MVP is built, the company would actually need an additional project modeled after what Piedmont Gas successfully did to access natural gas through MVP. Was that your testimony?
no,
Okay, can you explain that to me?
no, we would have, the first phase that we spoke about was providing gas to our existing, additional gas to Zone 5 that would be available to improve the liquidity in Zone 5 and provide upstream gas for our existing combined cycle fleet. And we would not need that type of project for that.
But just to clarify though, for that sort of what you called the first phase, you would envision that that would come from the completion of the MVP project
That is, yes,
under the company's first preferred scenario.
yes.
And then you also contemplated some sort of a build out and an upgrade of MVP at some point thereafter. Is that correct?
Yeah, that would be a potential to get incremental Zone 5 gas.
And so by incremental, you mean not firm?
No, I mean incremental to the first 525.
But you would envision that that would all be firm supply.
Yes.
Okay. So then second option, and I'm going to come back to MVP, but then second option, if MVP doesn't work out, is to attempt to do something similar with transporting from the south on Transco.
Or any pipeline from the south. But
Okay.
yes,
But same premise, some updated or some upgrades necessary to provide you that incremental additional firm.
that is correct.
Okay. So then going back to MVP, you're aware, are you not, that FERC extended the construction permit through October 2026, but that MVP has indicated it's hopeful that it will complete construction by middle to end of next year?
I am familiar with that.
Okay. And are you aware that in response to that ruling from FERC, that MVP indicated that one of the reasons it was pleased by that ruling is that the capacity for MVP remains fully subscribed under long-term binding contracts? Have you seen that phraseology from MVP?
Yeah, I understand that.
Okay, so yesterday, does that indicate, based on the information you gave yesterday, that Duke is one of those parties that would?
Chair Mitchell,
Oh, I apologize. I didn't mean to go into confidential information.
yeah, to the extent we're going to go any further, I think we would need to go into confidential session.
Oh, I have no desire to go into confidential session. Let me move on. Has the company done any analysis or sort of looking at the timing of when it would decide to transition from its pursuit of its preferred path with MVP to the alternative pathway through some southern transport with Transco or some other pipeline?
Yeah, I think we discuss a pivot that would take place if the northern route was no longer an option.
My question is, when would you make that decision? Would you be willing to go until October 2026 if MVP wasn't built and then say that's the time to pivot, or have you considered some earlier pivot date?
I think it'll depend on how the marketplace unfolds over the next couple of years with respect to pipeline.
So it sounds like at this point in time, you haven't identified some, if not built by X date, we pivot. It's going to be
It's going to be, yeah, the dynamics will play out and there will be a decision at a future point.
okay. So then you pivot to some southern pipeline option. Do you have any idea or estimate? And understand, I remember yesterday you sort of indicated that you've got some familiarity, but some of this really isn't within the scope. So please let me know if you're not the right person. But how long it would take for a southern pipeline option to perform the upgrades that would be necessary to bring the gas that you would need?
Chair Mitchell, I don't know where the line is of what needs to go into confidential session, but I feel like this is also pushing on that in terms of what a Southern Pipeline project would need to, the timing of when that would need to go into service. So I don't know, Mr. Snyder, I guess I would just remind you that there is a line and just want to make sure you're only answering questions that are acceptable to be answered in public. And if you're not comfortable answering a question, we can either go into confidential session or move on if that's appropriate. with
Let me,
council.
let me try a high-level answer that would not, I think will be dependent upon the nature of that, to the extent trying to do as much brownfield as possible. And the nature of that project would determine the timeline. And I think that would be about all I want to sort of say on that one. On that, once you pivoted, then it would be the nature and scope of that pivot project that would determine that timeline.
And so if I'm going to pose a question and you let me know if it's something that would implicate confidential information and we can move on. So can you it sounds like there's sort of a range of options depending on how the project scope. Are you able, without implicating confidential information, to provide me a bracket of how long a project could take from the shortest amount of time to potentially the longest, high level?
Yeah, I would, and again, subject to check, because this is outside sort of the scope of my direct area of responsibility, but it could be, a couple of years to multiple years, 3, 4, beyond. So I would think it's not a matter of months. It is years, and I'm going to give you a broad range of, 2 to 4 years, let's say, as a very, very broad range.
Yeah, that's all the more detail I was looking for. Thank you, Mr. Snyder. Those are all the questions that I have.
Good morning, gentlemen. Lucy Edmondson from the public staff. You'll be excited to know I'm not going to ask any questions about natural gas. So first, one clarifying question. I believe I think Mr. Snyder indicated to the chair that the near-term plans for all 6 portfolios were the same.
I said they're generally supported, actually 12 portfolios if you look at the alternates. So yeah, I think they're generally supported by all of the analysis.
Isn't it true that under portfolios P5 and P6, they do not economically select offshore wind until after 2040?
The near-term action plans call for just the development work, so it's not the in-service of offshore wind. And I think all of the portfolios show a need for offshore wind, as Mr. McMurray and others have testified. We're going to need these. It's a matter of when and not if. You're going to need this diverse array. And I think I testified that P1 and 2 economically select offshore wind. P5 was a stress on P1 and 2. So it put in transmission hurdle rates. It had a different gas assumption. It had, different battery optimization assumptions that can influence whether or not offshore wind, the timing of offshore wind. So it was not in that stress test. It was not selected, but P1 and 2 did select 800 megawatts of offshore wind in P1, and then there was 1,600 in P2 that were in the nearer term. So you're correct. That stress test in 5 and 6 did not have it, but I view that as a stress and not as a primary.
And development of offshore wind, would you agree it takes generally somewhere 10 years or so? Is that?
Yeah, that's what I understood from the long lead time panel. So I'm going to sort of leave it there and let them opine further on that.
Thank you. Okay, 3 modeling questions. I'm not sure who gets these. So Commissioner Hughes was discussing with you of transparency in the modeling and whether the post-processing tools for calculating PVRR were shared with interveners.
I remember that.
You've testified before that Duke received a significant quantity of discovery in this proceeding.
That's a fair assessment.
And would you agree that many of these data requests were related to modeling inputs, outputs, PVRR calculations, and general modeling questions?
Yes, they were.
So would you agree that the sharing of work papers, calculations, methodologies that are directly involved in calculating model inputs, such as the real levelized fixed charge rate and analysis of model outputs such as PVRR would cut down on the discovery?
Yeah, we've been talking about ways in this hearing to expedite that. And, you know, the only thing I would add to that is I think we need to think of that also as a two-way street. So the same level of transparency that we're trying to provide, we would just ask that however we work future processes is reciprocal in nature, such that, you know, we don't have 2 weeks while someone else has 3 months with the same level of data. So subject to that, you know, trying to be a little bit more reciprocal in nature and symmetric in the sharing of data and tools and underlying, I think there are ways we could provide that. Some of these, we put all the data sets up there. We could probably put some additional information right when we file, and I think that would help.
Right, thank you. Commissioner Hughes asked you about the use of a typical day representation of load in the capacity expansion model. And you responded how that biases resource selection towards short-term batteries.
It does have a bias towards overvaluing batteries. Yes, I remember that conversation.
Could this issue potentially be addressed in the capacity expansion models by changing the model intervals to provide more granularity in the daytime rather than using 6 equal intervals of 4 hours each?
No, I mean, it goes well beyond that because you still have to maintain peak and mins as it was explained, plus energy. So that's stretching. So I'm not saying the intervals, but I'm not saying that there aren't improvements that could be made. But at the end of the day, the screening model is always going to be a more simplified model. And I think there are enhancements that will get you closer. So you don't need to you won't have as many production cost 8760 differences. So trying to get those two to get closer is something we're going to strive for. But recognizing the purpose, and again, we talked about using the right tool to answer the right question. At screening, you're screening tens of thousands of options. So you have to use simplification. Production cost, you're using one portfolio, 8760. So I do think there's improvements that can be made. I think the vendor is looking into it. The industry is looking into it. We're looking into it. But at the end of the day, there's still going to be a need to go to more detailed production cost modeling to verify and fine tune the results you get out of a screening model.
You just mentioned some enhancements. Could you expand on what you mean by that?
Yeah, I think enhancements in how you, with the recognition that time shifting is now one of the key aspects as opposed to just meeting energy and peaks. Anything we can do to improve at the screening level, better representations of the time, not having such a distortion in the peaks to the mins would be beneficial. But at the end of the day, with storage, whenever you take a simplification, what I'm saying is, you know, it's day in, day out value is going to depend on an 8760, which is just not possible at the screening. So I think limiting that distortion, getting the time steps, looking at different options for those can start to move you in the right direction.
Someone's going to pass out an exhibit for me. Did y'all give it to the witnesses?
Yeah.
We do not. Thank you, Mr. Burns.
Very, very important. All right, we already discussed this morning some of the lumping of all new technologies that you discussed with Commissioner Brown Bland. And then Commissioner Hughes also asked you about typical day representation. And you talked about the solar plus storage dispatch and how these resources were modeled as DC coupled resources, unable to charge from the grid.
Yeah.
Have you seen this document before, or any information about this new version of Encompass 6.2?
I'm going to allow Mr. McMurray is.
Sure. This was released, I think, last week. So I know that some of the folks in my group, they are reviewed it. We're just now uploading it into our developmental server. Often before we really, we test everything that's in the notes before we say it's ready for production. So we're in that testing phase right now. But I knew that 6.2 has been released, and we're in the testing phase right now.
And would you agree that it represents that this would allow DC coupled solar plus storage to charge from the grid? According, that's what the release indicates.
I was looking for an opportunity yesterday to bring that up when it was discussed, but that is an enhanced feature that they're now offering. But as I stated, we have not tested it yet, and I think we'll get there. I mean, I'm not trying to backpedal at all, but this is the first time we've had a tool that would allow us to access that.
All right, well, how long will it take to test that before you will know whether you'll be able to use that functionality in future carbon plans?
I've got several folks that are several people within my group that are supporting this hearings. So that's slowing down the testing somewhat, but typically a couple of weeks.
Okay, great. That's all I have. Thank you.
Thank you.
No questions. Thank you.
All right, with that, we've come to end of cross-examination of this panel. So you all may step down. Thank you very much for your testimony over the past 2 days. I'll take motions. And Duke, your witnesses are excused.
Thank you, Chair Mitchell. The company would move the modeling panels rebuttal exhibits into the record. I think there were 3.
All right, hearing no objection, it's allowed, motion is allowed.
Chair Mitchell, SIG for 2 and 3 would move that modeling panel rebuttal cross-examination confidential exhibits 1, 2, and 3 be entered into the record, as well as SIG for 2 and 3 modeling panel rebuttal commissioner's questions confidential exhibit 1.
Motion is allowed.
Thank you.
CCBA would move the admission into evidence of CCBA modeling panel rebuttal confidential cross-examination exhibit 1.
And that motion is allowed.
I did not have the exhibit marked, and I apologize. If the Anchor Power Solutions release 6.2 could be marked as public staff modeling panel rebuttal commission questions exhibit 1, we would ask that that be entered into the record.
All right, the document will be marked as Public Staff Modeling Panel Rebuttal Commission Questions Exhibit 1. Hearing no objection to your motion, the exhibit will be admitted into evidence.
And may I ask one clarifying question?
You may.
So I brought to the attention of witness yesterday the July 28th letter that was filed in this docket. And I did not enter it as an exhibit because it's part of the record. Is that appropriate, or should that be entered into the record?
Abundance of caution, the commission will take judicial notice of the letter filed in this docket on July 28th by Deck and Depp.
All right, thank you so much.
Good morning. Laura Nichols on behalf of Duke Energy. We call Laura Bateman to the stand.
All right, good morning, Ms. Bateman. We will get you sworn in again, please, ma'am. Raise your right hand, left hand on the Bible. Do you swear testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God?
Miss, oh, wait till you're situated. Miss Bateman, are you the same Laura Bateman that previously appeared in this proceeding on September 19th with Mr. Nelson Peeler as part of the company's utility operations panel in our direct case?
Yes,
And did you cause to be pre-filed in this docket rebuttal testimony consisting of 11 pages?
yes.
Do you have any additions or changes or corrections to your rebuttal testimony at this time?
No, I do not.
If I were to ask you the same questions today that appear in your pre-filed rebuttal testimony, would your answers be the same?
Yes.
Does your rebuttal testimony contain any confidential information?
No.
Chair Mitchell, I would ask that Ms. Bateman's rebuttal testimony be entered into the record as if given orally from the stand.
All right, motion is allowed.
Ms. Bateman is now available for questions from the parties in the commission on her rebuttal testimony.
All right, let me check the latest version. Sigfer, you're up first.
Thank you, Chair Mitchell. Good morning, Ms. Bateman.
Good morning.
You previously testified in this docket on September 19th. Is that correct?
Yes.
Okay. Are you aware that the Public Service Commission of South Carolina issued an order on September 21st, 2022 in docket number 2019-224E and 2019-225E?
What docket is that?
If I could, I'll go ahead and have an exhibit. Pass around. Which SIG 2 and 3 would request be marked and identified as SIG 2 and 3 Bateman rebuttal cross-examination exhibit number 1.
So no, I am not aware of this order, and I think I previously testified that I was not involved with this docket.
All right, let me, before we continue on, let me identify the document as SIG 2 and 3 Bateman rebuttal cross-examination exhibit 1.
Thank you, Chair Mitchell. So do you have that document in front of you, Ms. Bateman?
Yes.
Could you please turn to page 7? And could you
Yes.
please read for the record the paragraph beginning in its modified IRP Duke designated portfolio C1?
And then how far do you want me to read?
The whole paragraph, please.
Okay. In its modified IRP, Duke designated portfolio C1 as its preferred portfolio. This portfolio fails to incorporate the commission-required input assumptions as dictated by order number 2021-47447 and reflects an aggressive carbon management strategy that is unsupported by South Carolina law. In fact, the base case A1 portfolio was projected to have a present value revenue requirement of $43.5 billion as opposed to the C1 portfolio, which is projected to have a present value revenue requirement of $46.9 billion. Duke modified our IRP, corrected page 10 of 116. The C1 portfolio requires significant and unsupported deviations from the least cost planning principles that are relevant in the base case A1 or pursuant to order number 2021-447A2. By contrast, in its original IRP, Duke did not specifically indicate a preferred portfolio plan, but did undertake that its base case portfolio A1 would incorporate least cost planning to meet its projected energy needs. And I would just add that, I know they've been excused now, but the modeling panel was involved with this docket in South Carolina, and I think they could provide more context to the order, whereas I was not involved, so I can't provide that context.
Understood. I actually don't have any other questions. Thank
Okay.
you.
Good morning. Craig Shower on behalf of CUCA. On page 8 of your testimony,
Of the rebuttal?
yes, thank you. You addressed the request of the public staff and certain interveners to provide an all-in cost calculation.
Yes.
Do you recall that?
Yes.
Did you review the testimony of James McLawhorn of the public staff?
Yes, I did.
Do you recall that he noted certain costs were not included in Duke's PVRR calculations?
Yes. Do you have the point in his testimony?
Do you have a copy of it?
I do.
I believe it's at page 19, lines 11, 16. It's probably what you're thinking of.
Yes.
And some of the examples are transmission costs, such as the red zone, were not included. Correct?
Well, no. So I'm glad you brought that up because I did want to address that. I've been hearing this theme throughout the hearing. And so I want to be clear on what is included and what's not included in both the PVRR calculations and the rate impacts. So I believe the modeling panel testified that there's a generic transmission cost estimate included in their modeling that approximates the cost of the red zone projects. So I would say that those are included, not specifically project by project, but the overall generic cost is included for those.
Okay.
We included projected DSM EE costs, so those are included. We included projected coal plant securitization savings, so those are included. And in various groups at different times testified that these were not included. So I want to make sure that it's clear. There's an assumption around hydrogen conversion costs that is included. It's not in the bill impacts because it happens in 24 later than 2035. And then I've heard significant questions about second license renewal. And that is one item that is not included. The costs are not included, but the benefits are not included either. And for that, the cost savings, we project that the cost savings will outweigh the costs. So in fact, in our upcoming rate cases, there will be savings that will be passed on to customers as a result of that assumption of second license renewal in those cases. So there will be a bill decrease that outweighs the increase.
And one of the items on page 19 that he lists is costs associated with Duke's grid improvement plan. Are those costs were excluded from the PVRR calculations, correct?
So yes, but I want to address that. So, and I think I put this in my rebuttal testimony. We have a 3-year detailed plan for grid investments, and there is no grid improvement plan anymore. There is just a plan for grid investments, and it includes both, base routine work and then work that might be considered more extraordinary. So we have a 3-year detailed plan that we have filed with this commission for DEP that we will soon file for DEC. And when we file our rate cases in the coming months, there will be rate impacts included associated with that grid improvement plan. And I think it is important to note that there are some items that are not included in the projections. We don't have a grid investment plan beyond that 3 years, a detailed one like the one that we filed here, the one that you can really give good rate projections on. And so any projection would be highly uncertain beyond that period. So when you get to 10, 15 years out, the rate projections would be highly uncertain. We can't project, I think he included storm costs. We can't project future storm costs. And so there's a lot of things that aren't related to the carbon plan, and it would be very difficult for the utility to project those, and we wouldn't be able to project them with any level of certainty. And I hear interveners saying, you should provide this, you should provide this. But we have asked, and I have asked and tried to find any other utility in the country that provides these type of projections 10, 15 years out. And I have been unable to find that. We asked Discovery on it. I talked to some of my peers in other states. I put a question out on the EEI rate subcommittee, looking for anyone that does this, and I haven't been able to find it. And I think there's a reason for that. When you think about the type of modeling and the type of bill projections and PVRR that we presented in this carbon plan, it includes a lot of assumptions, and those input assumptions might change over time. But the real value is to compare the portfolios. And I was listening, I've been listening to this hearing, and I heard NCSEA witness Baradarajan, I think this was on Friday afternoon. He was being crossed on differences between his model run and the company's model run. And he said, well, the main difference is that his run was later in time. And so it included different fuel inputs. And that was normal, that input assumptions change over time, so they change the absolute outputs. And I think he used the phrase, this is why we focus on the comparison between the scenarios rather than the absolutes. And I agree with that. I think that is important. Input assumptions are simply estimates and they will change over time. But the real value is in the comparison. And I get very concerned. Again, I've been listening, and I heard SIGPR witness Mueller testify that he would use such rate projections to make business decisions, to make decisions about where to locate a plant. And that's very concerning to me, because I know that those absolute values can change based on changes in the input assumptions, based on changes in inflation, interest rates, fuel costs. And so if he's going to do that, one, I get concerned, what would he be comparing it to? Would he be comparing our projections to another utility's current rates if they don't have a projection, which would lead to a bad business decision, or could lead to a bad business decision? Or if that other utility does provide a projection, there's no way to guarantee that we're using the same input assumptions. And so he could be looking at apples and oranges projections and again, make a bad business decision. And so not only do I think it's unrealistic and not of value to provide those projections, I think it could be dangerous and misleading for some customers that may not understand that those projections can't be relied on and can't be taken as a certainty of what the rate will be in 10 or 15 years. But instead, they're estimates and they're good for comparison purposes, but shouldn't be taken as absolutes.
Thank you. That was a very long answer to a yes or no question. But
Well, I
I want
wanted to make sure that it was clear.
and I'm going to revisit some of the things you said, so I think it's helpful. But one thing I do want to make clear at the beginning, just to make sure, you did say that the grid investment costs that you've modeled 2 to 3 years out are not included in the PVR calculations, correct?
Yes, to the extent that they are not related to generation additions.
Right, and then in your answer, you also mentioned that in Discovery, you asked for interveners to provide instances in which other utilities had provided long-term all-in cost forecasts, correct?
Yes, I asked several interveners.
And do you recall that CUCA did respond to that data request and provided an email exchange between you and Kevin O'Donnell?
Yes, let me get to that.
Okay. So you're familiar with that email exchange?
Yes,
Okay. And the exchange occurred on July 10th of 2021, correct? Or at least the final exchange, I should say.
so I have some email exchanges from April. And then I have some from April. I don't have the July one.
I see. I think the copy we produced signals that it was forwarded at a later date, but I think the last exchange between you and Mr. O'Donnell was on April 12th of 2021. Is that what you have?
I have an exchange from April 15th.
Okay, well, why don't if I could have a second, I'd like to hand out an exhibit, which is what CUCA produced in response to the data request Duke issued.
If I could just, for the record, note that the email exchange appears to have occurred in April of 2021, but the top of the email shows that it was forwarded somewhere on July 10th. So if that helps anyone clarifying what we're looking at.
Yeah, and thank you. That's something that I realized as I was starting to embark on this line of questions. So thanks for clarifying that. Chair Mitchell, I'd like to mark this as tech customers operations panel rebuttal cross-examination exhibit 1. All right, and so.
Okay, well, 1 minute, please, sir.
Sorry.
We're actually gonna identify this document as Tech Customers Bateman Rebuttal Cross-Examination Exhibit 1.
All right, thank you. Thank you, Chair Mitchell. So the exchange shows April 12th, 2021, at least on the copy that I handed you. And it is email from you to Mr. O'Donnell and Mr. Maness of the public staff, and there's an Excel sheet attached to
Yes,
the email exchange.
Yes.
Are you familiar with that Excel sheet?
I am.
Okay. I have attempted to print out the Excel sheet, which was attached. And as all Duke's modeling Excel sheets go, they are unwieldy, but I think I captured everything to the best of my ability. If you flip to the first page of the Excel sheet, which says summary chart,
Yes.
at the top, it shows that this calculation includes the IRP base plan. Could you explain what that is?
That's from the 2020 IRP. It was the base case plan.
Okay. And then the next column is all T&D, including grid mod. Could you explain what that means?
Yes, and I want to give a little bit of background here.
Sure.
And so Mr. O'Donnell had taken a number that Lynn Good had referenced in, I don't know, some public forum, maybe an investor call or something like that, about how many billions of dollars we would spend on capital investments for T&D over the next 5 years. So Mr. O'Donnell took that and then misunderstood that amount. And then he assumed it was all DEC, when in fact it was both DEP and DEC. And then he assumed it was grid improvement on top of our base T&D spend, but it was not. It was total T&D spend. And so based on those two assumptions, he calculated some bill impacts using, standard revenue requirement calculations, and then started sharing those with legislators. And so I felt the need to correct his incorrect assumptions because they were leading to very distorted results that were being shared publicly. And so we took that, and I forget, it's probably in the details here, X billion dollars, spread it, made some high-level assumptions to spread it to both DEC and DEP. And then, instead of being on top of base spend, it was the total amount. So we modeled that correctly. And then just made a high level assumption for after the 5-year period that, some normal level of spend would continue. So pretty high level assumptions, but more accurate than what Mr. O'Donnell had modeled. And so we kind of revamped that and then shared with those assumptions what the bill impacts would be for that T&D. And so I want to give that background that, these were never intended to be, you can absolutely count on this is going to be your bill impact in 2030 or 2035. These were not based on detailed plans, and it was to correct, grossly wrong estimates that were being shared publicly to get more in the right ballpark of what people should expect.
And the calculation you performed was through 2035. So it was a 15-year forecast.
Yes, and then I also want to note, it's on here, note 2 says it does not include coal ash, maintenance investments at existing non-fossil plants, general or intangible plant, depreciation of existing rate base or changes in ADIT for existing plant and service, or other changes in rate base, changes in O&M, changes in tax rates, or other unforeseen cost changes. High-level analysis assumes perfect rate making for all costs allocated at a high level, not at a more precise cost of service level as would be done in a rate case. So I think that's pretty clear that even these are not all in costs and should not be relied on to, make business decisions or for customers to make business decisions, that these are high level and they are not all in.
Given the risk of customers performing bill impact analyses with incorrect assumptions that would produce distorted results, wouldn't it be better for ratepayers and the public for Duke to perform those calculations and provide accurate information for them?
No, because during this process, Mr. O'Donnell and I had some back and forth. And one thing that he said is that we both know that both of our projections are wrong because they are simply projections based on inputs, and those inputs are just projections, and they may or may not change over time.
Right, just like the PVRR calculation is inevitably going to be wrong because it's going to evolve.
And I have said that I thought the PVRR was valuable for purposes of comparing portfolios, and that's what I think the value of that is.
So one of the reasons you said that Duke could not perform a all-in long-term price forecast was because of interest rates, inflation, fuel costs, and a few other assumptions, correct?
Yes.
Right. And the PVR calculation, which Duke provided as part of the carbon plan, includes assumptions about interest rates, inflation, and fuel costs, does it not?
Yes. And so I didn't say that you couldn't do projections, you couldn't do modeling that includes those assumptions. But where I get concerned is if, and I think Witness O'Donnell stated this, that we should be held accountable to that it should be taken as certainty that those will be the bill impacts in 10 or 15 years. And I think in the portfolios that we've presented in this docket, no one has made that assertion that these are the absolute, costs that you can count on 15 years from now. But using consistent assumptions across the portfolios that you can have, that they are valuable for comparing portfolios.
No further questions.
Good morning.
Good morning.
Ms. Bateman, Carrie Grunman on behalf of Walmart. I actually do want to follow up on one of the issues that you discussed in one of your responses to Mr. Shower's question. You indicated that in the course of discovery, you asked the public staff, Sigfer and KUKA, if they were aware of forecasts, 10 to 15 year forecast being provided by any other parties. And you indicated that no one had such forecasts.
Correct. Or no one provided any forecasts.
Your Honor, I'd like to mark an exhibit for the record.
And we did not ask Walmart because, well, Walmart didn't file
the question.
testimony on this issue.
But had Walmart been asked, I might have been able to have provided a response. Your Honor, I'd ask that we mark this exhibit as Walmart Bateman Rebuttal Cross-Examination Exhibit 1.
All right, the document will be marked as Walmart Bateman Rebuttal Cross-Examination Exhibit 1.
Ms. Bateman, do you have a copy of this exhibit in front of you?
I do.
I
and-
will
hold on.
represent to you that this is an excerpt. It is the front page and then a page 8 from the Virginia State Corporation Commission's final order in case number PUR 2020-00134, which involved Virginia Electric and Power Company doing business as Dominion Energy.
Okay.
And it involved requirements under the Virginia Clean Economy Act. Do you have some base level familiarity with that legislation?
Yes.
And to the extent we need to refer to it, I have my copy here, but do you have the SIGFR 2 and 3 Carolina Utility Operations Panel Direct Cross-Examination Exhibit 7 in front of you? It is a copy of the VCEA. It's entirely possible you don't have it, and if so,
Was it? Yeah, I was going to say if it was handed to me on my direct testimony, I have it somewhere in here, but
I have it. So to the extent you end up needing to refer to it, I'm
Okay.
happy to do that. But if I could direct your attention to the second page of this exhibit, which is marked as page 8 of the commission's order. Are you aware that beginning in 2020 and continuing for 15 years, that the utilities in Virginia are obligated to file annual RPS plans with the Virginia State Corporation Commission?
generally familiar.
Okay, and as part of those plans, directing your attention here to page 8, do you see that the Virginia Commission has directed Dominion to file projected customer bill impacts information through 2035 associated with its RPS development plan? And that among other things, it has to provide customer bill impact information over the next 10 years for its lease cost plan, the company's preferred plan, and any additional plans presented by the company?
I see that here, but I also want to note that I actually spoke with Robert Trexler from Dominion about the projections that they provide. And he indicated that even their projections are not all-in projections, that there are certain costs that are excluded.
I guess my point was, is you were asked if any parties had that, and this does indicate that there is another utility, one who's in a neighboring jurisdiction that is providing bill impacts associated with complying with clean energy legislation.
They are not providing all-in bill impacts. And that's what my testimony was. I mean, we provided bill impacts of the carbon plan in Appendix E. But they were not all-in bill impacts. And just like Dominion provides bill impacts for certain things in their legislation, they are not all-in bill impacts. So I think that's what I was saying, is that we don't have, I couldn't find another utility that provided all-in bill impacts that would encompass everything such that a customer could look at that and make decisions about what their future rates would be.
But you do understand here that separate from a PVRR, the Virginia Commission has ordered the utility Dominion to file bill impacts associated with the compliance with the VCEA.
Yes.
And you understand that.
And we filed bill impacts associated with the carbon plan in this proceeding.
Well, bear with me just a second. As part of the VCEA, you understand that the company is obligated, that Dominion is obligated to retire its carbon emitting generation. Are you aware of that?
Yeah, I'm not familiar with all of the details of the requirements.
Well, can you accept that subject to
I
check?
can accept that subject to check.
And are you aware that one of the other steps that has occurred in Virginia to address the Virginia Clean Economy Act's unique legislation is that specific cost allocation methodologies were proposed and adopted by the Virginia Commission?
I have no reason to dispute that.
And that as part of those methodologies, all costs and benefits will flow through those riders, including fuel costs for Virginia for carbon-free resources that comply with the VCEA?
So I just want to be clear. So there are certain costs that flow through their riders. Is that what you're saying? They're not all costs that flow to customers are in the riders, though.
I'm just asking if you understand that there's a specific methodology that recovers all costs associated with those particular facilities.
So I'm not familiar with that, but I can accept that subject to check, that there are specific costs that flow through riders.
Wonderful. Thank you. Those are all the questions that I have.
Um, public staff.
No questions.
Okay, redirect.
Sure. Ms. Bateman, if you would look at the exhibit that Ms. Kress provided to you on cross-examination regarding the recent Public Service Commission South Carolina order.
Yes.
She asked you to read a paragraph on page 7 of that order at the bottom of the page.
Yes.
And I just wanted to note, if you could look at the cost differential, the PVRR differences between portfolio C1 and that was Duke's preferred portfolio and what the commission adopted. What's the magnitude of the difference between those two amounts?
It's 3.4 billion, but given the magnitude of the numbers, it's pretty small,
And
relatively small.
And could the IRA impact what those amounts end up being?
Absolutely.
And if you would turn to page 9, could you read paragraph 4 of the findings of fact there?
The utilities and stakeholders are given clear and consistent direction of the regulators regarding resource planning. The utilities being expected to implement the best practices in an ever-evolving situation are not bound by a specific resource plan, since by the very nature, those plans may change as more information becomes available.
And then could you look at paragraph 6 and read that?
The commission decision to adopt A2 does not interfere with efficiencies of dual state planning. It is incumbent upon the utilities to recognize that North Carolina and South Carolina have different statutory structures, which at times align. In other instances, however, due to specific regulatory requirements unique to a single state, dual state planning must accommodate those differences.
And is Duke working to come up with a framework to address the dual state planning and potential state differences?
Absolutely. And that's what I referenced when I testified in my direct testimony. And then when I was on the stand for direct testimony and then referenced in my rebuttal written testimony that we are working on developing that framework that can maintain the dual state system, which we believe is a benefit to customers and has been a benefit to customers over many, many decades, but allow for differences in state policy.
And SIGFR has taken the position in this proceeding that if costs are not, that costs should be allocated to South Carolina, and if those costs are not authorized by the South Carolina Commission, that shareholders should have to bear those costs. Do you agree with that position?
No. I mean, I think there's a basic fundamental principle of utility rate making that a utility should be allowed an opportunity to recover its reasonable and prudently incurred costs in the provision of service, utility service. And so I think as we're looking forward, that, we are developing this framework, but I don't think that this commission can impose costs on South Carolina. I don't think North Carolina can impose costs on South Carolina. I think we need to develop this framework that if North Carolina wants to build a certain generation project and South Carolina doesn't, that there's an opportunity to allow that, where North Carolina customers have North Carolina generation that they pay for and receive all the benefits of. And South Carolina, in the same way, can have South Carolina generation that maybe they pay 100% of and receive 100% of the benefits of. And then generation that is jointly, that serves both states. But I don't think that, especially as we look forward to what we should invest in going forward, that it would be fair to order the utility to pursue certain generation. And then knowing that South Carolina doesn't want to pay for it, but ordering that some of the costs get allocated to South Carolina so that there's no opportunity for the company to recover its reasonable and prudently incurred costs. So I think that that's a fundamental principle that we need to keep in mind as we navigate through this.
Thank you. Nothing further.
All right, let me see if there are questions from commissioners. Okay, Commissioner Duffley.
Good morning.
So I'm a lawyer, not an accountant, so I
Okay.
have some accounting questions that I just want to get clear in my head.
Yeah.
So in the filings, the company has stated that they've modified their petition and they're not seeking deferral of costs related to long lead time resources. Is that correct?
Correct.
So I just want to know what accounts are going to be used.
Yes.
So will those costs go at first into account 183 or 183.2? Or both?
So I'm not familiar with 183.2.
Okay, so 183 is preliminary survey and investigation charges, and 183.2 is entitled Other Preliminary Survey and Investigation Charges.
So I would need to check on that. We typically just refer to 183 as 183.
Okay, that's fine.
I
And-
apologize.
And then once the activities, either you have filed a CPCN or you have obtained a CPCN, those charges will move to account 107, or those costs will.
So I'm not sure what the trigger point is, but if that project is pursued, so that could be the trigger point, the CPCN, then they move to 107.
So you answered my follow-up question was, where is that trigger point? And you're not sure today?
Correct.
Okay. And then ultimately, if the project reaches commercial operation, those costs would move to account 101?
Correct.
Okay. Thank you. And if the charges do not, or if the project does not meet commercial operation, at that, when you know that point is when you might seek a deferral?
Yes. So if it's determined that it's no longer prudent to pursue that project, then the cost would most likely, if we thought they were probable of recovery, we would likely move them to a 186 deferred debit account, and then seek a permission to move them to a regulatory asset from this commission.
Okay, thank you for that. And then you heard Ms. Boswell's testimony regarding section 62-110.7.
Yes.
I didn't see any response in the rebuttal. I'm in the legal brief right now. And I just want to confirm, when I read this, I wasn't quite sure. Do you consider this a 110.7 proceeding, or do you see, I understand you're saying there shouldn't be a separate proceeding, but are you saying this equates with that proceeding?
So I'm not saying either of those. I believe we addressed kind of the legal side of that in our September 9th comments. From my perspective, it goes back to that basic rate making principle. If it's reasonable and prudent for the utility to pursue these development activities and we execute them in a reasonable and prudent manner, then we should be allowed an opportunity to recover those costs.
I understand that answer. Thank you. Moving to page 6 of your rebuttal testimony.
Yes.
So you're responding to public staff's testimony regarding cost allocation of carbon plan costs between DEC and DEP. And you obviously heard Mr. McLaughlin's testimony in which he had concerns about what happens if the merger is unsuccessful. And then we're several years down the road and no work has begun with respect to closing this rate disparity. And I just want to give you an opportunity to talk about that, please.
Yeah, and I appreciate that because I did hear that testimony and maybe I was not clear in my testimony. My testimony is that I don't think we need to implement an interim solution, but I do agree with him that we need to be pursuing the merger, but concurrently developing alternative solutions if the merger is not able to be achieved.
Okay, thank you for that clarification regarding that. And just remind me, how long did it take to align OPTI and OPTV rates? I've gone back to an old rate case,
So
if you remember.
I am familiar, because I believe that was actually right around the time of the merger that DEC previously had OPTI and OPTG rates, and
Is
now
it G or V? Was it G?
I think now the new rates are OPTV.
V.
I think it used to be separated by industrial and commercial,
Okay.
kind of SIC code. But when they moved to OPTV, it's now differentiated by voltage level and size.
But there was the use of gradualism with respect to those issues. Do you remember?
I am not familiar with that.
Okay, not a problem. And then my last question it's on page 7. And it's with respect to why in the P2 version is the differential larger than all the other portfolios?
And so I think it just has to do with the timing of when resources go into effect. So I had looked at that, and I think it is just an issue of timing. Speaking of those large files, I print on big paper. Yeah, I think it's just timing of resources. There's some production cost savings, but not a whole lot coming into service in 2026 in those portfolio or differentiation between what's coming into service in 2026.
Okay, thank you.
All right, Commissioner Plattfelter.
Ms. Bateman, good morning. I'm not sure how far I want to go with this. And I'm not sure how far you can go with this, but I want to try because it's just gnawing at me. And I recognize that this is something we'll probably be talking about, or someone will be talking about a lot more in 2024 and 2026 and 2028 than we can talk about today. But in your rebuttal testimony, you do have a little bit of discussion about the state alignment problem. And I understand from your direct testimony, you say that the company is trying to develop some framework to address the contingency that the South Carolina Public Service Commission and the North Carolina Utilities Commission diverge.
Mm-hmm.
And I understand that, and I know you're working on it, and you don't have a lot of detail you can share with me today. But one of the things you say on page 11 of your rebuttal testimony is that you do agree with SIGFR on the principle that if there are costs that one jurisdiction bears that the other jurisdiction refuses to share in, that the benefits should go to the jurisdiction that's covering the cost.
Yes.
And what's gnawing at me is I'm just sitting here trying to figure out how that could possibly happen. I mean, let's suppose, and I think with a concrete example, because that's the way I think about it. So suppose we here say, we love Bad Creek and we love offshore wind and we want you to go all out on Bad Creek and offshore wind. And the Public Service Commission says, in South Carolina, says, we're not going to have South Carolina ratepayers paying for those. How do we get all the benefits? I mean, the energy that's going to land from the undersea cable from that offshore wind facility is going to go onto the grid, and it's going to be available across the entire bi-state grid. It's going to be, the capacity is going to be available when it's needed for peaking. The energy is going to be available to customers everywhere. And if you've got a reliability concern, you're going to call on the resource for South Carolina customers as well as North Carolina customers. How do we get 100% of the benefits?
Yeah, and so we have been thinking through this, and so I can lay out, some things that, some kind of current thoughts, and they all have issues that need to be worked through and fleshed out. But one idea, which is probably more complex, and the short answer is it's in the accounting. So one idea is to look at marginal cost. And so you would have a North Carolina stack and a South Carolina stack. And I kind of wish my co-panelist, Nelson Peeler, was here with me because he could explain this better than me. But when you have the dispatch of the system, you would dispatch both. And let's say you used offshore wind. If that was a North Carolina only resource, that would be in the bottom of the North Carolina stack. And then you would kind of dispatch up. And so if South Carolina didn't have any South Carolina specific resources, they would reach the top of, or North Carolina would reach the top of the stack more quickly, and there would be a transfer price for that generation that is at the top of the stack. And so you would have like the variable, so whatever unit is being dispatched at the top of the stack, the most expensive variable cost unit, you would take, South Carolina would have to purchase that energy from the North Carolina stack. And so it would be transferred over in an accounting adjustment to move that cost to South Carolina. And then there would be, I believe public staff asked about this, there would be a capacity component as well. And so some sort of marginal capacity cost, and how you determine that, there's many different ways that you could do that, but some sort of capacity cost would have to transfer over. So that's one way to look at it, as marginal, marginal energy, marginal capacity. Another way to look at it is average embedded. And so using the wind example again, you would look at the total kWh output from that wind generation and the total kW at the times of peak from that wind facility. And you would adjust the North Carolina allocation, you would adjust your allocation factors to remove the kW and the kWh that were served from that wind generation facility. You would remove that load from the factors and then use an adjusted factor with that load removed to allocate the rest of the generation portfolio, both the energy costs, the variable costs, and the capacity or demand costs. And so those are just an example of two different ways that you could do it. There are probably others. We are early on in looking at this, but there has to be a way. We believe there is a way to do it. And we're hopeful that there's a way to do it that is acceptable to both North Carolina and South Carolina that's fair. And so what's not fair is for North Carolina to pay 100% for a generation facility and South Carolina to get energy from that facility for free. But we think there is a way to do it, either by looking at marginal costs and developing a stack for each state, kind of similar to how we do the JDA today, or looking at it from an embedded cost or an average cost perspective.
Thank you for that. I think that's as far as we ought to go, or I want to go today, because this is I mean, it's a long-term contingency, but I just wanted to get started thinking about it.
Yeah.
And you've given me something to chew on. Thank you.
Okay.
And my thoughts were along similar lines as Commissioner Clotfelter. What have you thought about in terms of the red zone improvement costs, particularly in light of where some of the improvements and upgrades would occur? I mean, and you may not be in a position to elaborate further today, but I think it's a concern that we all share.
Are you talking about North Carolina, South Carolina?
Yes.
Or, okay. So for transmission, I believe transmission is a little different than generation. For transmission, there are system network customers, and they should pay for all of the system network costs. And so I think that's if you're a transmission customer of the system, you need to pay for all of the costs. And I think the red zone projects would fall into that. Now, I have read testimony both by public staff witness McLaughlin and in, I believe, the NCEMC comments, where they talked about that those projects, well, I'll talk about public staff. I think witness McLaughlin said that they are projects that are resulting from state policy. And I believe NCEMC referenced an example in New York where some transmission projects were designated as state policy projects. I think if you designate them as state policy projects, then you make the argument that they should be North Carolina only. But if they are simply network upgrades to accommodate new generation on the system, they would be network costs that would be paid by all network customers.
All right, thank you.
All right, thank you, Ms. Bateman, for your testimony today. I don't have much for you, just to kind of pile on to questions that you've already been asked. Did you hear Mr. McLaughlin's testimony that he provided in the hearing room several days ago?
Yes, I did.
Okay. I took away from his testimony a strong sense of urgency to address the discrepancy between DEC and DEP rates, and you've addressed that some in your pre-filed testimony and some in response to questions you've been asked today. But this is my concern. You know, there is some dissonance between where the public staff is and where the companies are on the issue of addressing the disparity in the interim before we have a final decision on a merger of the two companies. And so can you respond beyond what you've already said in your testimony, having heard Mr. McLaughlin's strong feelings that he expressed in this room the other day?
Yeah, I can. And I'll say that I don't know that Mr. McLaughlin and I are, that our views are that far apart. So one thing that I want to clear up is, and I don't think Mr. McLaughlin is saying this, but that any existing rate disparity between DEP and DEC is not the result of something that Duke has done wrong, or that Duke should have been working since the time of the merger to make these rates more even or close that gap. We seek to make the rates for DEP and DEC as low as possible. We do not try to make them more even, and that would be contrary to our requirements to avoid cross-subsidization per the regulatory conditions, code of conduct, et cetera. We try to avoid cross-subsidization. So we do not just charge DEC customers in order to make the rates more even. But I don't read witness McLaughlin's testimony to imply that we've done something wrong or that we should have been addressing the existing rate disparity. In fact, when he lists the reasons for it, he references several things that DEP was required to do, such as the purchase of solar PPAs under PURPA, previous purchases under PURPA. So I want to be clear on that issue. I don't think we're as far apart as it might appear. When I read Witness McLaughlin's testimony in both this docket and the 2022 solar procurement docket, my understanding is that his view is that because HB 951 is a statewide policy, a statewide mandate for carbon reduction, that the cost should be spread more evenly between DEP and DEC, and that either both utilities should be able to should be required to individually meet that mandate, or if they're going to jointly meet the mandate the way that we've modeled it, and through that joint, through meeting the mandate through a joint plan, more of the costs end up in the DEP service territory, that there has to be a way to more evenly spread those costs. Because otherwise you would have DEP customers subsidizing DEC, that they would be paying for cost for DEC to comply with the requirements of HB 951. And so I think that is a valid point. And I do think it's something that we need to work on. But when I look at the differences in 2026 and the revenue requirements, 4 of the 6 portfolios actually reduce the rate disparity in 2026. And then the other 2, P3, DEP's rates increased by 8 cents more per megawatt hour. And just to translate that, that's approximately 8 cents on the typical residential bill. Portfolio 4 is 55 cents difference between the DEP and DEC rate impacts, and that's about 55 cents on the typical residential bill. When I contrast that with the differences in 2030, the 2030 differences, the DEP residential bills are anywhere from $12 to $27 higher than the DEC typical residential bills. So I think 2030 is we need to address this issue before then. I don't see the issue before 2027. I will say, given all that, so it's my testimony that it's not necessary to implement a remedy before 2027. And I don't even know that it's really, I don't think it's necessary. And I think any solution has complications to it. And we testified that the most straightforward solution was a merge of the utilities. And that's a pretty complicated process. But given all of that, if this commission does think that there needs to be a remedy before 2027, I can say that in our upcoming rate cases, we will have an alternative option for the commission on how to split the costs of certain projects between DEP and DEC.
Okay.
It's not our base recommendation, but we will have an alternative option.
Okay, thank you for that explanation. And just following up with you on one issue. So the companies have stated an intention to pursue merger and have provided us with a timeline, and sort of anticipated timeline. And we don't know what the outcome of a merger request would be, given that the companies would have to achieve approval at multiple levels. And I want to make sure I understood your testimony to Commissioner Duffley. The companies would be working concurrently on a fallback plan were the merger not to be approved
Yes.
as to allocation of costs between the two companies. Is that correct?
Yes.
Okay.
And we would work together with the public staff
Okay.
on that,
Okay.
on both.
Thank you for confirming. I just want to make sure I was clear there. Okay, I have one last question for you. I'm hoping you can answer. If not, then I'll ask somebody down the line. Do the companies have to pursue or secure approval on the Bad Creek project from South Carolina?
I would ask that question to the long lead time.
Okay,
panel.
got it. Okay. All right, that's all I have. Let me just make sure no other questions have come up. Okay, we will take our morning break, and we will be back on the record at 11. Go back on the record, please. We will continue with questions on commissioners' questions. Who's up first?
You want to go ahead?
We're going in alpha order. Okay. Thank you, Chair Mitchell. Ms. Bateman, I have a few follow-up questions from your discussion with Commissioner Clodfelter, and I just want to make sure I understand. So if North Carolina ratepayers are receiving all of the output, all of the benefits from a generating asset, then North Carolina ratepayers would also be allocated all of the costs for that asset. Is that consistent with your testimony?
Yes.
Is that the same thing as the direct assignment method that you discussed in your pre-filed rebuttal testimony, or is that something different?
That would be, yes, that's the same.
So
Yes.
that's what you were discussing with Commissioner
Yes,
Clodfelter
yes,
with the
that you would
direct
have
assignment?
North Carolina only, you would have joint resources, and then going forward, you could have North Carolina only resources or South Carolina only resources and joint resources.
Thank you for that. Now, the direct assignment method that you were discussing with Commissioner Clodfelter and as referenced in your rebuttal testimony would be a departure from the cost allocation assumptions in the carbon plan. Is that right?
Correct.
So given that it would be a different cost allocation methodology or solution, I think is a word that you used when discussing the state alignment issue. Given that it would be different than the assumptions made on that issue in the carbon plan, wouldn't it be reasonable to ask Duke to supplement its filings with the information as modeled under these different assumptions?
So I don't think we're at a point yet to model this. We're still in the development, still very much brainstorming and developing these frameworks. So it's not at a point where we could model a portfolio with assumptions under this new framework. It's not developed to that level yet.
Okay. If you'll just give me one moment to check my notes. Chair Mitchell, I just asked that the commission take judicial notice of the North Carolina retail production demand and transmission allocation factors for DEP and DEC as set forth in Exhibit A and B to the agreement and stipulation of partial settlement filed on September 13th, 2022 in docket numbers E2 sub 1300 and E7 sub 1276.
No objection.
All right, commission will take judicial notice.
Thank you. Nothing further.
Good morning again, Ms. Bateman. I wanted to follow up on some of the questions that you were asked by Commissioner Duffley. I think that she started by having you confirm that the companies have withdrawn their request for deferral accounting treatment of the long lead time resources. Do you remember that question?
Yes.
And then she asked you, and I'm not an accountant, and I want to only kind of set the ground for my questions, but she had talked with you about if you subsequently sought a CPCN for long lead time resources, and she asked you whether the cost, did she ask if the cost would move from FERC account 183 to 107? Is that?
Yes.
And I think your response said if you sought a CPCN, that's what would occur.
So no, I said that could be the trigger point, but I wasn't sure what the trigger point was for moving costs from the 183 account to the 107 account. I did get a little bit more information during the break, and it's still a little bit nebulous, but it's when a decision is made to move forward with the construction project. That's when it moves to 107. So that could be some senior management approval. That could be the application for a CPCN. It could be a variety of triggers, but when a decision is made to move forward with the construction project, that's when the cost moved to 107.
Okay, so my notes, I appreciate that subsequent clarification because I do think it helps. But my question, my notes don't reflect it in the way you just described it. But the way I wrote it is that you said if you sought a CPCN, that would happen. And so my question was, are there long lead time projects for which that it's your understanding that a CPCN would not be needed?
I would ask the long lead time panel.
Thank you, Ms. Bateman. That's all
But
my
yeah,
question.
I did want to clear up that it's not necessarily that a filing for a CPCN is the trigger to move it to 107.
No, thank you. I appreciate the clarification, and I'll check on this issue with a long lead time panel. Appreciate you. That's all the questions I have.
Good morning, Ms. Bateman.
Good morning.
Just a couple of questions. In response to Commissioner Clodfelter's questions about separating the physical loads and energy between jurisdictions.
Yes.
Would you agree that rates and revenues today are set on an embedded or average cost basis, and only the small curtailable loads are set on a marginal basis?
I'm sorry, say that again.
So that rates and revenues are set on an embedded or average cost basis, and marginal basis is generally just used for small curtailable loads.
So I might disagree to some extent. So I would agree that rates are generally set on average embedded costs, especially for joint resources that are shared and allocated. The allocations are of embedded average costs. I do think, so I would point to the JDA where there's transfers between DEP and DEC. I believe those are at more of a marginal cost. Certainly purchases and sales with other utilities that are either economy purchases or I'm blanking out on this, like a bulk power marketing sales would be done at more of a marginal cost basis. So there are some things that are marginal, but mostly embedded.
Thank you. Is it possible to separate the physical capacity demands and the energy consumption of two interconnected jurisdictions without severing the transmission and distribution wires that interconnect the two jurisdictions?
So I don't have an answer to that, but I think, what we're proposing, the framework that we're proposing doesn't involve a physical separation, but would be achieved through the accounting. And it would still maintain the dual state system, and all of your existing generation would still be allocated or jointly shared between the states. But as we move forward, could we, through accounting mechanisms, have generation that is direct assigned to one state versus the other?
Could you give more, any details about how the accounting would work or how the cost would be allocated based on this accounting method?
So not beyond what I provided in response to Commissioner Clodfelter.
Okay, thank you. That's all I have.
Ms. Bateman, you cleared up the question about when project costs moved from account 183 to 107. Did you also get some clarification on account 183.2? Is that something we use?
No, that we have, we would put costs in just 183.
Nothing further.
All right, at this point, Ms. Bateman, you may step down and you are excused. Thank you very much for your testimony this morning.
Thank you.
And I'll take motions.
We don't have, Ms. Bateman doesn't have any exhibits, but we do have her summary of her rebuttal testimony that we would move into evidence.
We'll copy her testimony summary into the record at the appropriate time.
Thank you. Nothing further.
SIGFR 2 and 3 would ask that Bateman rebuttal cross-examination exhibit 1 be entered into the record.
All right, hearing no objection, your motion is allowed. Thank you.
Chair Mitchell, Craig Shaw on behalf of CUCA, I'd like to correct an error in the record. When I introduced an exhibit, I misidentified it as tech customers, Bateman rebuttal, cross-exam exhibit 1. It should be CUCA, Bateman rebuttal, cross-exam exhibit 1.
All right, Mr. Shower, for the record, the document that had been identified as tech customers Bateman rebuttal cross-examination exhibit 1 will be corrected to be identified as CUCA Bateman rebuttal cross-examination exhibit 1.
All right, and Chair Mitchell, CUCA asked that CUCA Bateman rebuttal cross-examination exhibit 1 be moved into evidence.
All right, hearing no objection, your motion's allowed.
Thank you, Chair Mitchell. Walmart would ask that Walmart Bateman rebuttal cross-examination exhibit 1 be admitted into the record.
Hearing no objection, that motion is allowed.
Thank you.
Duke, call your next witnesses.
Good morning, Andrea Kells for Duke Energy. And Duke calls the transmission and solar procurement panel to the stand.
All right, good morning, Mr. Roberts, Ms. Farver. Let's get you sworn in. Raise your right hands, left hand on the Bible. You swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right.
Good morning, Mr. Roberts. Are you the same transmission panel that appeared in this proceeding on September 19th through 21st of 2022?
Yes.
Did the panel cause to be pre-filed in this docket on September 9th, 2022, rebuttal testimony consisting of 43 pages and 3 exhibits?
Yes.
And did the panel also cause to be pre-filed in this docket on September 27th, replacement rebuttal pages 27 and 43?
Yes.
Do you have any changes to your rebuttal testimony or exhibits at this time?
No, I do not.
And if I were to ask you the same questions today that appear in your pre-filed rebuttal testimony as updated on September 27th, would your answers remain the same?
Yes, they would.
And none of the panel's rebuttal testimony or exhibits are confidential, correct?
That's correct.
Did you also prepare and cause to be pre-filed a summary of the panel's rebuttal testimony?
Yes.
Chair Mitchell, I move that the transmission and solar procurement panel's rebuttal testimony and summary be entered into the record as if given orally from the stand.
All right, motion's allowed.
I also ask that the panel's 3 exhibits be marked for identification as pre-filed.
Exhibits to the panel's testimony will be marked for identification as they were when they were pre-filed.
Thank you. The panel is now available for questions from the parties in the commission.
All right. Let's see, we've got CC.
Thank you. For the court reporter, my name is John Burns with representing CCBA. Good morning, panel.
Good morning.
I have just a very few questions for you. I noticed that you filed, or Duke filed amended testimony that corrected, well, in particular, the testimony on page 43 of your rebuttal testimony related to the build, own, transfer procurement process. Is that correct?
That's correct.
Ms. Farber, could you tell us what the essence of that change is?
The earlier draft of the rebuttal testimony stated that we were not going to pursue a build, own, transfer option for standalone storage. And upon further reflection, we've edited that to allow for further discussion about the potential benefits of a build, own, transfer arrangement for standalone storage.
So it's the company is now open to the discussion and possibility of build, own, transfer for standalone storage.
Yes, we'd like to learn more about that.
Okay. I also have a quick question. If you'll turn with me to page 2 of your testimony as revised. I don't think the revisions affect this page, but you're discussing, and I'm not, Mr. Roberts, I think this is you. In response to the question, Mr. Roberts, what is the purpose of the transmission and solar procurement panel's rebuttal testimony? You list some things and then discuss table 4-13 of chapter 4 of the execution plan, correct?
Correct.
Okay. I just have a quick question. You list 5 things, 5 actions there from that original table. The 4th is perform further transmission planning evaluations and studies for transmission transformation needed to facilitate coal generation retirements. And the 5th is requesting interconnection studies for needed megawatt levels of offshore wind. for once, I have a question that's not a targeted cross-examination question, and it's just a question of what is the difference for all of our understanding between the types of transmission planning evaluations and studies you mentioned in 4 and interconnection studies in 5? What's the practical and real difference between those types of studies?
Yes, so a retirement study is specifically that. You're looking at taking the existing generation away. If you don't replace it on site, what transmission upgrades will be needed? Performing a more formal analysis associated with that retirement study. Versus an interconnection study, you're saying, I want to connect a certain level of megawatts at this point of interconnection, and you're studying that injection into the system through our formal LGIP process.
Okay. So the studies contemplated in paragraph 4 there are specifically related to the coal generation retirement. So there's not transformation planning evaluations and studies that might apply to a different type of problem that Duke is evaluating.
So it's specifically meant to apply to retirement of generation and not replacing on site.
Would it be possible to do the transmission planning and evaluations of study and evaluation/studies for other issues that are before this commission, such as the 3 wind lease areas?
I'll let the long lead time panel
That's a fair response. Thank you.
respond to that.
I appreciate that. And for the panel, both of your rebuttal testimony spends a good bit of time emphasizing the need for the RZEP projects, correct?
That's correct.
And there's nothing that's changed between your original testimony and your rebuttal testimony that would have the company backing off from its assertion that these red zone projects are essential for the implementation of the carbon plan.
So we definitely believe the RSET projects are essential for executing the carbon plan. After we filed our direct testimony and the supplemental studies as exhibits that indicated 15 of the original 18 projects showed up as being impacted through the supplemental studies. The public staff responded through their direct testimony and recommended an additional 3 projects to be delayed, monitored, and they offered that we could provide a different stance if we wanted to in our rebuttal testimony, in which I do. I respond that 2 of those 3 projects, based on certain parameters, such as enabling a certain amount of solar and the benefits that they provide, are still needed.
Would you agree that the red zone, proposed red zone projects would be at least an early example of the type of proactive generation plus transmission planning that is needed as we go forward with the carbon plan?
Yes, that's indicated in my direct testimony and my rebuttal testimony that it is an example of the proactive transmission multi-value network upgrades that are going to be needed to execute this carbon plan.
I also note that there's some discussion in your rebuttal testimony about the proactive transmission planning, which you've just identified red zone as an example of that. But the process itself with the NCTPC, would the company are you in a position to speak for the company as to whether the company would be open to changes in that process to involve the comments and proposals of parties other than the transmission operators?
So could you point me to the section you're referring to?
Well, I mean, you don't actually go into that, and I'm struggling to find your exact part. Let me look back at bear with me one moment. I can make this more efficient. In the discussion after page 3, I believe, related to the red zone, you then go further to talk about pardon me. I just hold on and I'll be right there. Sometimes I lose my place. We'll strike that. I'll just ask a different question. In terms, with regard to the NCTPC process as it currently exists, is Duke open to changes in that process to more fully involve stakeholders in the decision-making process in NCTPC as to the approval and disapproval of proposed transmission upgrades?
Yeah, so I think the avenue for stakeholder involvement is sufficient with respect to the transmission advisory group and being able to provide input on local projects identified through the NCTPC process and studies, and suggest alternatives or suggest that it may miss the mark. And we have to, per the FERC process in attachment N1 in our oath, we have to address that feedback. That's the whole purpose of the stakeholder process. I do think since the entities that are ultimately responsible for paying for the transmission, as far as FERC projects go, they should be the ones making the decisions, the ultimate decisions. But we're required to absorb that input from the TAG stakeholders and address that.
Isn't though the TAG process by its very nature currently reactive to proposals of projects that are identified as needing transmission upgrades as a result of the project?
So no, I think any proposals, we can't accommodate 100 proposals in a year, but I think any proposals we could address through the NCTPC process through a study, and we've done that. The public staff has requested to analyze a future portfolio through the NCTPC process. I do think we need to change the manner in which we conduct the studies such that they're more aligned with our generator interconnection studies, and thus the results are more in line with what we would see from the generator interconnection study once the interconnection customer makes that request and goes through the DICES process.
I'm going to ask one of those questions that a lawyer shouldn't ask, which is one that I don't know the answer to, but how would you suggest, Mr. Roberts, that the generation planning be more involved with the transmission planning as part of the NCTPC process? Because we've all talked about that as what we understand to mean by proactive. How do you logistically do that in the context of the current NCTPC process?
Yeah, so there's multiple ways, but public policy request, and then we receive input from that developer or planner, and it states, here's what we offer as input for locations and sizes of megawatts for a certain type of resource, and we can study that.
And would it be possible to use the public policy process, the public policy request process, if that request came from the commission itself?
So the public staff has issued a public policy request to the NCTPC, and we conducted the study. I think that would be a proper route. I think the OAT allows the commission to have that avenue through TAG to submit a public policy request, but that's subject to check.
Thank you. No further questions at this time.
All right. Who's up next?
I believe Sigford,
Okay.
Chair Mitchell. I think I have just two questions for the panel. Good morning.
Good morning.
You were in the hearing room this morning when your colleague, Ms. Bateman, testified about jurisdictional cost allocation issues. Is that right?
Yes.
Could classification of RZEP projects as public policy projects potentially create additional jurisdictional cost allocation problems?
So I'm not an expert on jurisdictional cost allocations. I know, FERC's stance is that network transmission is to the benefit of all network customers. So all the network customers in DEP would benefit from the network upgrades associated with the RZEP projects. All the network customers in DEC would benefit from the RZEP projects in DEC. That is FERC's stance.
Thank you. Nothing further.
All right, CPSA.
Good morning, Ms. Farber, Mr. Roberts. Mr. Roberts, I'd first just like to follow up on CCB's last couple of questions about transmission planning, just very briefly. Would you agree that in an integrated transmission and resource planning process, a series of portfolios are provided, and then those portfolios get studied to identify what they would mean in terms of transmission upgrades?
So that's a scenario-based approach.
Okay, is that the is a scenario-based approach the way Duke would recommend we move forward with the transmission planning?
I think as mentioned by other interveners, it has to be a holistic approach, and you basically have the expansion plan, and through input from this commission, we now incorporate network upgrade cost proxies into that decision-making associated with the selection of those resources. And so I mean, that is baking in the transmission. Then, once you have that network cost proxy, you need to make sure that that proxy, reflects what actual upgrades are. That's why we go back to generator interconnection studies, if we have them, to develop those cost proxies. Looking forward out, from what I'm hearing from interveners, and what I agree with, is that a proactive transmission planning approach looks at that transmission needed to facilitate that resource plan holistically, and you maximize the overall benefits looking at the cost holistically.
Thank you for that. So I just want to understand, as Duke foresees it in the TPC process, that the TPC itself will study a resource plan or portfolios. Is that right?
The TPC process, yes, can study a portfolio.
Okay, and how does the TPC know what portfolios to study? Or let me ask it another way, where do those portfolios come from?
Right, so usually in the past, we've looked at an approved IRP, and based on that approved IRP, things like dates for generator retirements, that goes into the models that are studied associated with that portfolio.
Understood that that's how it's been done in the past. I guess what I'm asking is, how do you foresee the resource planning process or the carbon planning process feeding into the TPC going forward?
Right, so we may have to, based on what this commission approves as carbon plan, if it's near-term actions, we make sure those near-term actions are represented in the models. If it's a certain portfolio, or maybe it allows for a range of portfolios, 3 or 4 portfolios, then we could look at those 3 or 4 portfolios.
Okay, all right, thank you. Ms. Farber, I'd like to ask you some questions about the red zone upgrades. So you testify that the red zone upgrades will allow for more interconnection of solar facilities in the red zone, right?
That's correct.
Okay. And you say, and I'm looking at page 6, start with line 11 of your rebuttal testimony. So I guess this is on line 15. You say that to date, these red zone upgrades have created insurmountable cost hurdles for developers of 1 or 2 projects being asked to bear the upfront burden of that cost. Is that right?
That's correct.
And I would paraphrase your testimony as saying that the RZEP will create benefits for a large number of projects, but if the cost is allocated to a small number of projects, it makes their economics untenable. Is that a fair characterization?
Yeah, historically, yes, those costs have made those projects in the past untenable.
But Duke believes that the RZEP are an efficient investment if the whole amount of generation that will be facilitated by those upgrades is considered. Is that right?
That's correct.
And based on the supplemental study that Duke has performed, that additional generation is somewhere north of 3,600 megawatts. Is that right?
Correct. And Mr. Roberts can weigh in on the supplemental study.
All right.
Yeah, so the supplemental studies did show that subject to check around 3,600, a little over 3,600 megawatts would be enabled by the red zone projects. It also identified that there could be other upgrades. There could be upgrades locating outside the red zone. There could be other upgrades locating inside the red zone.
Understood. Thank you. Ms. Farber, I'd like to ask you a couple of questions about the current DICES process and the RFP, if I may. You testify in your direct testimony, we can go there, but just I do want to establish, you say in your direct testimony that there are approximately 5,000 megawatts of solar in the current RFP, about 70% of which is in the red zone. Is that right?
That's right. We corrected that to approximately 4,900 megawatts, but it's still approximately 70% of the megawatts.
Thank you. So that's about 3,500 megawatts, give or take?
Roughly.
Okay. And that's approximately the number of megawatts that the supplemental studies say would be facilitated by the red zone upgrades, right?
Correct.
Okay. So moving to DICES, DICES is a two-phase interconnection study, isn't it?
Yes, it is designed to be phase 1 and phase 2. There's a provision that if a phase 3 is necessary, it could continue.
And in phase 1, Duke conducts a power flow study of all the projects that go into DICES, right?
That's right.
And that study identifies the upgrades that are required to interconnect all those projects, doesn't it?
Correct.
And it allocates the cost of those upgrades across all of the projects that participated in phase 1 according to their impact.
Yes, that's more or less true.
Okay. So going back to the number of megawatts that are in DICES and the number of megawatts that are considered in the supplemental study, would you agree that in the phase 1 study of the current DICES process, the costs of the red zone upgrades will be spread among roughly the same volume of projects that will ultimately be facilitated by those upgrades?
I think that's more or less accurate. Of course, the projects that are in this current DICES are different, or potentially some of them at least are different from what was studied in the supplemental study. And so we don't know which of these projects are contributing to which of the specific red zone upgrades, but from a sort of high level standpoint, yes, they will be allocated the costs across the projects that are there. And furthermore, there might be projects outside of the RFP that are in DICES that are also picking up a portion of that cost if they're in the red zone.
Understood. Thank you. So would you agree that the allocation of costs to red zone projects in DICES phase 1 provides a very rough but probably conservative approximation of the cost those projects would be allocated if you spread them across all the projects that would benefit from the red zone upgrades?
It is one way to create an approximation, but because, when we say red zone, we often just lump them all together, but there are distinct projects within that, and every solar project is going to have a different defects or contribution to each of those specific upgrades. So it would be one mechanism to draw a very rough approximation, I think.
Thank you. Moving on to the phase 2 study, you'd agree that you likely have fewer projects in DICES phase 2 than were in phase 1, right?
Well, the number can only go down since no projects can be added, and projects will make a decision about whether they choose to move forward into phase 2. That's right.
And most, if not all, of the projects that are not selected in the RFP will likely drop out prior to phase 2. Is that right?
I can't speculate on what those projects choose to do. So I don't think I can specifically answer that.
Okay. Well, how about this? Unless a project that is not selected in the RFP has another way of establishing offtake and thereby meeting the readiness requirements for phase 2, they'd be likely to drop out before going into phase 2, wouldn't they?
They would have to establish a different form of readiness in order to continue in the DICES process.
Okay. And so would you agree that the phase 2 study will identify upgrades and allocate costs based on a smaller set of projects than the phase 1 study?
It will be, sure, either the same number or a smaller number of projects than in phase 1. That's right.
And if the red zone upgrades are triggered in phase 2, the costs would be allocated to a smaller set of projects, wouldn't they?
Whichever projects are remaining, that's correct.
Understood. And commensurately fewer projects would ultimately, well, if it's a smaller number of projects, then the cost will be allocated to fewer projects than will ultimately benefit from the red zone upgrades, won't it?
That is, can you repeat that?
Sure. If a number of projects drop out after phase 1 and before going into phase 2, and the red zone upgrades are triggered, then the full cost of those red zone upgrades will be allocated to a smaller set of projects, right?
Sort of, because we don't know if all of those upgrades identified in phase 1 will still be necessary in phase 2. So as there are fewer projects, perhaps there are fewer upgrades needed. But to the extent that the upgrades are still needed in phase 2, then that cost would be allocated over a smaller number of projects. And there can and likely will be future projects that would also benefit from those upgrades.
Thank you. And here's where I'm going. Did you happen to hear commissioner questions yesterday on the modeling panel during which Chair Mitchell expressed concerns about whether we were sending appropriate price signals to solar projects with regard to locating in the red zones?
I caught some of that discussion. I'm not sure if I caught it all.
Okay. Would you agree that if no costs for red zone upgrades were allocated to solar projects, that might send an inappropriate price signal to developers in the near term?
Can you explain what you mean by inappropriate price signal?
That's a great question. If I'm, and I'm going to take a risk here and try to paraphrase the chair, but I believe that she expressed a concern that if the red zone upgrades got incorporated in the local transmission plan and there were no costs allocated to projects locating in the red zone, that would send an inappropriate price signal for projects to develop into the red zone because they wouldn't be bearing any cost for those upgrades.
I do think the cost of the red zone upgrades needs to be considered when you're looking at the portfolio that you're selecting, but how those costs are allocated, whether it's falling to the generators individually through the DICES process or through the red zone process, I'm not sure that makes a difference. So in the evaluation, I think you should consider what the associated transmission impacts are, regardless of how those transmission costs are borne, I suppose.
Thank you. Well, let me ask you another question. Would you agree that for purposes of bid evaluation, it would be inappropriate or it would send an inappropriate price signal to fully allocate the entire cost of the red zone upgrades to a smaller set of projects that will ultimately benefit from them?
So this is one of the challenges with, I suppose, proactive transmission planning, that we have assumptions and we're using information that we have available to us about the scope of projects that we believe will be utilizing or can utilize these upgrades. But our view into the future isn't perfect. So understanding what that full denominator is of the full number of future megawatts that will benefit from these upgrades is impossible to specifically define right now. We know that there will be future megawatts and we can look at specific scenarios, but it is unclear just how many megawatts we should spread that cost over to come up with sort of an LCOT.
Yeah, that's absolutely correct. And I mean, it's going to depend on location and size as well. I mean, one of the things we're pretty confident of is that the red zone expansion plan projects will enable larger solar facilities to be interconnected. And so that's that would allow more megawatts for a given number of interconnections.
Thank you.
That's one of the benefits.
Thank you. So given that there's all this uncertainty and it's probably difficult to create a perfect price signal for projects to develop or not develop in the red zone. Would you agree that the phase one cost allocations for the red zone upgrades might be an appropriate sort of proxy price signal for use in bid evaluations?
I would want to check with the team who's actually performing those evaluations. I think that taking that full number and spreading it across all of the megawatts in the red zone would be a very rough way to do it, since we don't know on a project by project basis which project's contributing to what at this point in time. It is one way to come up with a very rough approximation of how to spread those costs.
Thank you. Understanding it would be very rough, and for all the reasons we've discussed, do you think it would be appropriate to consider that as a way of setting an appropriate price signal in the bid evaluation process?
I think for future solar procurements, we should have further discussion about how best to account for transmission costs assigned to projects. I should say transmission costs assigned to projects for evaluation purposes, if those transmission costs are not being borne by the generator in the DICES interconnection process. So for a red zone upgrade, how are we making sure that we're not assigning a zero transmission cost to a project that's benefiting from red zone upgrades that were approved through a different mechanism, but also not assigning one project the full cost of all of the red zone upgrades, because that also is not an accurate reflection of the, I suppose, the project's cost.
Thank you, Ms. Farber. Moving on, Mr. Roberts, on page 27, starting on line 8 of your rebuttal testimony.
Okay.
On page 27, line 8 of your rebuttal testimony, you begin to provide your response to witness Watts's assertion that Duke should encourage third-party self-build of interconnection facilities and standalone network upgrades. Is that right?
That's correct.
And in your response on page 27, you first briefly discuss Duke's interconnection standards for transmission interconnected projects, correct?
That's correct. And that was part of the red line correction that was made. So,
all right, thank you. I'm sorry, can you tell me again what the correction was for clarification?
yeah, so just to paraphrase, on line 18 says must, if connected to a network 230 kV transmission line, must have a ring bus station installed at point of interconnection for protection and isolation purposes. And so with our criteria, you go through a criteria, so it's not an absolute that a ring bus is required. It's recommended, but it's not an absolute that is required.
Understood. Thank you. Moving on to page 28, excuse me, on lines 1 through 5, you talk about the need for line outages. Is that right?
That's correct.
Okay. And then the next thing you say is that because of this impact to day-to-day transmission operations, reliance on third-party construction introduces significant reliability risk. In fact, the DEC and DEP OAT and the modifications required by FERC Order number 845 acknowledge this distinction, providing the option for interconnection customers to build interconnection facilities and standalone network upgrades, not network upgrades that risk adverse reliability impacts. Did I read that correctly?
That's correct, but I'd like to put that in context. And what that's stating is that we basically need to be in control of reliability, right? I mean, NERC has us championing reliability, meeting the NERC reliability standards. We have to be in compliance with those 24/7, 365. And so what this is saying is that we don't want to create an outage such that a solar developer or any developer, any interconnection customer is working on interconnection facilities and putting that transmission system at risk, the energized transmission system at risk. The OAT does allow for, and I think Mr. Watts mentioned shoe flies or temporary line, as you defined it. And so the OAT does allow for standalone network upgrades, i.e. upgrades being built that do not put the network transmission system in jeopardy or reliability risk. That's what this is stating, this section is stating.
So I take it from your testimony that you agree that interconnection customer construction of standalone network upgrades does not put the system at reliability risk?
Right. I mean, we would have to assess that, but yes, that's what it's saying. And Order 845 from FERC required us to put that option into our open access transmission tariff. Every transmission provider has to have.
Thank you. So as you say, FERC has concluded that allowing interconnection customers to self-build interconnection facilities and standalone network upgrades does not risk adverse reliability impacts. Is that correct?
I don't know. That's FERC's explicit conclusion. I just know that they require the transmission service provider to allow for the provision of self-build options with standalone network upgrades, and that's what's in our tariff.
Okay, well, you say here that under the OAT, customers can self-build standalone network upgrades and also interconnection facilities?
Yes, that's correct.
Okay. All right, so Duke's OAT allows FERC jurisdictional customers to self-build interconnection facilities and standalone network upgrades, correct?
That's correct.
Okay, could you turn back to page 27, please, and read lines 8 through 11?
What is your response to Witness Watt's assertion that Duke should encourage third-party self-build of interconnection facilities and standalone network upgrades?
Thank you. So as you explain it, Witness Watts' suggestion is only that Duke should encourage third-party self-build of interconnection facilities and standalone network upgrades, correct?
I believe Witness Watts was referring to, well, I believe he generically referred to network upgrades. And so this specifically isolates that to standalone network upgrades, i.e. network upgrades that won't place the network transmission system at a reliability risk.
All right. Well, as you explain Witness Watts' recommendation in your testimony, you say that he's only recommending self-build for interconnection facilities and standalone upgrades, correct?
That's what I have stated in the question.
Okay. And that's already allowed for Duke's FERC jurisdictional customers, correct?
FERC Order 845 requires it, yes.
Okay. And if that were permitted for state jurisdictional interconnection customers, that would only allow those customers to do what FERC jurisdictional customers of Duke can already do, correct?
That's correct.
Okay. Thank you. Ms. Farber, would you agree that because of economies of scale, larger solar projects are generally, not always, but generally likely to have better economics than smaller projects?
That can be one contributing factor.
Thank you. Mr. Roberts, I'd like to turn to page 25 of your testimony, if I may.
Okay.
Okay, and on page 25, you say that, sure I have the right line number here. Sorry. On page 25, line 4, you say that the companies believe that 14 to 15 interconnections can likely be achieved in the near term. Do you see that?
Yes, and it further says, from a transmission perspective, this is reasonable but aggressive target.
Okay, so when you say 14 to 15, you mean transmission interconnections?
That's correct.
Okay, and in the near term?
Once again, it's based on outages. It's based on having to coordinate all the outages. I look back at 2021, we coordinated close to 1,100 outages, most in the spring and fall. So we have maintenance outages, we have NERC PM outages, we have outages for TPL 001 reliability projects, we have outages to connect new points of delivery for retail, new points of delivery for wholesale. there are a lot of outages to coordinate in order to ensure we maintain reliable electric service throughout each year.
Okay. Well, thank you,
Thank
Mr.
you.
Roberts. I didn't ask you about outages. I just asked you to confirm as you said here, that this is a near-term estimate.
I'm providing the reasoning for the 14 to 15 interconnections, and that 14 to 15, if you look at figure 15 in the modeling testimony, direct testimony, it shows that the red zone projects are needed to enable getting to 14 to 15 interconnections per year annually.
Okay, thank you. So that 14 to 15 interconnections per year, I mean, that's a current assessment, right?
That's correct.
Okay, thank you. Chair Mitchell, I would like to have marked for identification an exhibit. This would be transmission panel rebuttal. I'm sorry, CPSA transmission panel rebuttal cross exhibit 1.
All right, the document will be marked for identification purposes as CPSA, transmission, panel rebuttal, cross-examination, exhibit 1.
Thank you. Mr. Roberts, this exhibit shows the solar projects that are in DEC and DEP's combined interconnection queues as of July 10th, 2022. Do you see that?
Yes.
Okay. And I'll represent to you that all the information on this exhibit comes from DEP's and DEC's OASIS websites, and I'll further represent to you that it was pulled from those websites in the last 48 hours. So as far as I know, this is the most up-to-date information available. So this exhibit shows the combined DEC and DEP queues in the DICES study. Would you agree with that?
Yes.
Okay. And you see that there are both state jurisdictional and FERC jurisdictional projects on this table?
I do.
Okay. And would you agree that under HB 951, 55% of solar resources that are added will be owned by the company and 45% of solar resources will be third-party PPAs?
That's correct.
Okay. And would you agree that in the DICES process, PPA proposals go in the state jurisdictional queue and utility ownership proposals go in the FERC queue?
I can answer that. For our RFP, for those proposals that were bidding both both PPA and utility ownership track, they were instructed to have a state jurisdictional interconnection agreement. And then if they were selected for utility ownership track, they will change to FERC jurisdictional later.
Okay, thank you for that clarification. And state jurisdictional projects are not allowed to be any larger than, well, sorry, strike that. PPA projects bidding into the RFP are not allowed to be any larger than 80 megawatts. Is that right?
That's correct.
Okay. And let's see here. Utility ownership proposals, however, do not have any size cap, right?
That's correct in the 22 solar procurement.
Okay. And similarly, FERC jurisdictional projects have no size cap and state jurisdictional projects have an 80 megawatt cap. Is that right?
I don't actually know if state jurisdiction has a cap, but in order to qualify as a QF, it would be 80 megawatts.
Okay. You're not aware of there being any state jurisdictional interconnection customers that are larger than 80 megawatts, are you?
From looking at this report, no.
Okay, thank you. I'd like to direct your attention to page 3 of the exhibit, please. And do you see where it says average project size?
Yes.
Okay, and I will represent to you that these are just calculations based solely on the information that is shown on this table. Subject to check, would you agree that this says that indicates that the average size of a FERC project in Duke's DICES queue is 137.5 megawatts?
Subject to check.
Okay. And subject to check, the average size of a state jurisdictional project is 68.3 megawatts.
Subject to check.
Okay. And subject to check that the overall average size is 84 megawatts.
Subject to check.
And here's what I'm getting at here. We've had a lot of back and forth, I know, with Mr. Watts and Mr. Roberts about sort of qualitative reasons why or why not higher interconnection numbers might be achievable. I want to look at some numbers here and see what kind of interconnection rates might be achievable based on Mr. Roberts's estimate that Duke could reasonably achieve up to 15 interconnections per year. So with that, I'll tell you where I'm going. So, all right. And I'll say this was made a little bit more complicated by this 55-45% split. The math was not easy. Mr. Roberts, will you look at the, you see where it says potential HB 951 compliant portfolios based on DICES 1 project size?
Yes.
Okay, and I'll just represent to you that when this says HB 951 compliant, that means there is a 55% or approximately a 55%, 45% ownership split required by HB 951. So if you look at, you see the first of these tables that says average project size overall?
Yes.
Okay. And would you agree in this table that what this indicates is that with 7 PPA projects and 8 utility owned projects, all at the average size of 84 megawatts, that's a total of 15 projects?
Yes.
Okay. And would you agree that the total megawatts of those 15 projects at that average size is 1,260?
Yes.
Okay. And turning to the next box here, you see where it says average project size by category?
Yes.
Okay. And do you see where it says PPA projects 9 at 68 megawatts, which is the average size of PPA projects?
Yes.
Okay. And you see it says 614.8 megawatts?
Yes.
Okay. And you see where it says UOT or utility ownership projects 6 at the average size of FERC projects of 137 megawatts? You see that?
Yes.
Okay, and you see where it says 825.3 megawatts?
Yes.
Okay, so would you agree that with this hypothetical portfolio, you would end up with 15 projects with a total combined capacity of 1,440 megawatts?
Yes.
Okay, and just moving on to the last box that says largest project size by category. You see that?
Yes.
Okay, and you see where it says PPA projects top 10?
Yep.
Okay, and I'll represent to you that is just the largest 10 of the PPA projects on the list. So you see where it says 800 megawatts?
Yes.
So that would be 10 projects at 80 megawatts apiece. Would you agree with that math?
Yes.
Okay, and then you see UOT projects top 5, 1,038.3 megawatts?
Yes.
Okay, and I'll represent to you that is just the largest 5 of the utility ownership projects in DICES 1. And what is the total megawatts of those projects in that on that table?
Yeah, the top 5, 1,038.3.
Okay, so understanding that these are all hypothetical portfolios, would you agree that they all comply nearly with the HB 951 ownership split? And I'll represent to you that it's impossible to do it exactly with these project sizes.
The 45% PPA, 55% Duke ownership.
Yes. Mhm.
It's in the ballpark.
Okay. But would you agree that with a range of projects going from the average size all the way up to the largest project size, 15 projects could represent a portfolio of somewhere in the range of 1,260 to 1,838 megawatts?
Yes, and I mean, something in the middle is very close to our 1350 starting 2028 with respect to implementing the red zone projects.
Okay. Thank you. Those are all the questions I have.
Okay,
Good afternoon, Nick Jimenez, with the Southern Environmental Law Center for SACE et al. Couple questions for Ms. Farver. Let's see if you can hear me. Ms. Farver, you testified that there's now a strong foundation of established practices and structure, e.g. evaluation practices, bid documents, contract forms, on which to build in the future for solar procurements, right?
Can you point me to the page so I have it for reference?
Certainly, 34 lines 18 to 20.
Yes, I'm there.
And this has come through CPRE and now the 2022 solar procurement. It's the same reference.
That's correct.
And you were responsible for designing and implementing the 2022 solar procurement, right? That's
Yes, I coordinated the 22 procurement.
Thank you. Now CPRE was overseen by an independent administrator, right?
That's right.
And that was required by statute.
That's right.
And the 2022 solar procurement is overseen by an independent evaluator.
That's correct.
Are you familiar with Duke's petition to procure unawarded CPRE capacity through the 2022 procurement filed on September 1st, 2022?
Yes, I am familiar with it.
Thank you. I have a few questions about that. I'll represent to you. They're drawn from that petition. If you'd like to answer subject to check, that's fine with me, or you could answer whether you agree with the statement. That would also be fine. Part of Duke's justification for switching from an IA to an IE was that Duke announced that no Duke Energy affiliates will be participating in the 2022 SP, correct?
That is one of the factors.
And Duke's non-participation eliminated some of the risks identified in the Commission's original rulemaking order justifying the need for additional, more robust oversight prescribed by Rule R8-71 for the 2022 SP, correct?
Subject to check.
And those risks included Duke or its affiliates getting on the inside track by interacting with the IA, correct?
Subject to check.
Under the 2022 SP solar procurement, the Duke evaluation team does have a more significant role in bid evaluation and is responsible for selection of winning proposals, correct?
That is correct.
For future procurements, if Duke or its affiliates participate, then Duke should use an IA again, should it not?
I think that we have not designed these future procurements yet, and so it is too soon to know exactly the structure of those procurements or if affiliates would participate. But we are committed to having independent oversight, and I foresee using an independent evaluator in situations where Duke may also be bidding into the procurement.
Thank you. That's all the questions I have.
All right, tech customers. Public staff.
Thank you. Good morning, Mr. Roberts, Ms. Farver. I'm Robert Josie with Public Staff. Just have a couple of lines of, I think, mostly clarifying questions. Mr. Roberts, on page 31, you discuss onshore wind imports. Were you listening to the hearing on Monday when I believe it's Mr. Fitch, who is representing was witness for several different parties here, stated or discussed importing 2.5 gigawatts of onshore wind from the Midwest?
Yeah, I believe I caught that part of his testimony.
Okay. And he stated that he believed that the cost of the upgrades that would be necessary to import wind were embedded in the wheeling charges that would be charged for transmitting that onshore wind from the Midwest to North Carolina. Do you recall that?
So, I mean, it depends on the origin of the Midwest wind, and it depends on what provisions the transmission provider has in their tariff for establishing the rate.
Okay, so is it your understanding that wheeling charges and PJM and MISO include those upgrades that may be required to import 2 gigawatts of wind, onshore wind from PJM or MISO into North Carolina?
Right. If they just charge their standard point-to-point rate, and didn't design a special rate based on certain network upgrades required, then it would be the point-to-point rate, which is, we refer to PJM as a border rate.
Okay, and so would the construction of the upgrades that would be required to enable a party such as Duke to import power into the state be an additional separate cost from the point-to-point transmission cost?
So here's the total cost for wheeling power from, say, MISO all the way into the Carolinas. And this is just an example. Once again, there could be a special transmission rate, but it would be the point-to-point rate on MISO, the point-to-point rate on PJM, and then we would also have network transmission upgrades that would probably be necessary on the Duke system. And then you have the cost of the resource.
Okay. And could Duke's current transmission system import 2.5 gigawatts of onshore wind from PJM or MISO?
Not the current system, no.
Okay. Do you have any idea what the cost of those upgrades would be?
So we looked at, excuse me, we looked at importing 1.5 gigawatts and did that analysis, and that's what we're submitting or have submitted the transmission service request to PJM to validate that. We requested a TSR for 1,000 megawatts, but based on that, the magnitude was over $700 million, and the time frame was really the critical factor. It was 84 months associated with construction of those upgrades just on the PJM system.
Okay. So for 1 gigawatt, you believe it's going to be somewhere in the neighborhood of $700 million in upgrades to the transmission system.
So our study was for 1.5
Okay.
gigawatts.
So you would assume it would be quite a bit more for 2.5 gigawatts?
Yeah, it would probably definitely escalate.
Thank you. And then I just want to go back to a discussion you and I had on your direct testimony over the projects included in your rebuttal Exhibit 3. And of the original 18 projects designated as RZEP projects, Duke decided to remove 4, correct?
That's correct.
And the public staff Public Staff Witness Metz recommended that 3 of the initial 18 projects be removed from this RZEP. Is that correct?
So I'll just backtrack a little bit to get to Witness Metz's recommendation. So the supplemental studies identified 15 out of the original 18 projects. It did not include the Irwin-Milburn 230, the Sutton-Wallace 230, or the Rockingham West End West 230 lines. They didn't show up in the supplemental study. And then Witness Metz reviewed the supplemental study results, and he recommended that the Clinton 100 lines, the Irwin-Fayetteville 115 line, which was one of the original Frisian upgrades, and the Camden-DuPont 115 should be delayed also. And our response was, we respectfully disagree. There's quite a bit of solar behind the Irwin-Fayetteville 115 that it would enable. There's quite a bit of solar behind the Clinton 100 lines that upgrade would enable. But we agreed that the Camden-DuPont could be delayed, but only because it's kind of a shorter duration project. For example, the Irwin-Fayetteville was identified in the transitional cluster study as taking 54 months to complete that upgrade. The Clinton lines were identified in the DEC transitional cluster study as taking 48 months to complete. So once again, if you have a lot of solar that wants to interconnect and it's behind those upgrades, you got quite a delay. And that's what we're trying to alleviate with respect to getting these red zone expansion plan projects proactively in place.
Okay, and just to clarify, you say you have a lot of solar behind those lines, it's particularly the Clinton 100 kV. But in the supplemental study, it only showed 4 study hits on that line. Is that correct?
Well, there was actually, based on my assessment of the results, there was actually 740 megawatts of solar facilities that met the defects threshold and or the line loading impact threshold. And so if a solar facility met one or both of those thresholds, then that facility would be identified as a network upgrade need for interconnecting that solar facility.
Okay, thanks for that clarification. Ms. Farber, my next line of questioning is for you. See, your understanding that the commission issued an order approving request for proposals and pro forma power purchase agreements subject to amendments on the 2022 procurement on June 10th, 2022.
Subject to check the date, but yes.
Subject to check. And also, subject to check, the commission stated on page 9 of its order, ordering paragraph 4, that Duke is directed not to include the RZEP projects in the 2022 DICES baseline. Is that correct?
Yes, subject to check.
And is it your understanding of that ordering paragraph that the RZEP projects should not be considered in the evaluation of bids in the 2022 RFP?
They should be considered in the evaluation of bids, but not in the DICES baseline, was my understanding.
All right. Yes, thanks for that clarification. No further questions.
All right, redirect.
Mr. Roberts, do you have figure 15 from the modeling panel's direct testimony with you? If you don't, it's okay. I can. May I?
It's in my bag.
May I approach? Okay.
Oh, yeah.
Yeah.
And do you
let
have?
me know what page that's on,
Oh,
Mr. Roberts?
It's page 160, figure 15.
Okay.
and do you have with you the CPSA cross exhibit 1 that you went over with Mr. Snowden?
Yes. Yes.
Can you explain, you see the first couple, that figure 15 shows that interconnections over the course of several years, correct?
That's correct, starting with 2026, which would reflect the 2022 procurement.
And what are the interconnection levels there for the first couple columns?
8.
Okay. Can you explain to us whether that figure is consistent with the data in the exhibit that you discussed with Mr. Snowden?
Yeah, so as discussed with Mr. Snowden, he's got 15 interconnections, and we actually don't show 15 interconnections until 2030. We show 14 in 28 and 29. And so it's not entirely consistent with, and we do show the red zone expansion plan projects as enabling those increased interconnections.
All right, thank you. And just real quick on the questions about the third-party build that you went over with Mr. I'm sorry, I turned my microphone off. The questions about third-party construction of interconnection facilities.
Yes.
Is it your testimony that there's not really a dispute between your testimony and Mr. Watts on this matter, but just that, you know, those can't be allowed when there are negative reliability impacts to the system?
That's correct. That's the main issue is no reliability risk.
Thank you. No further questions.
Okay, questions from commissioners. I will check in with Commissioner Brown Bland, Commissioner Clodfelter.
Mr. Roberts, the retirement date for Marshall Units 1 and 2 is the earliest is the end of 2028. And I believe the Appendix P indicates that in order to achieve that date for retirement, you need to address a reliability issue on the McGuire to Marshall 230 kV line.
So
That's my memory, right? Am I correct?
you're about 98% correct.
All right, give
So
me the 2%.
The other 2% is that if you replace the generation on site with equal capability,
Right.
then you will still have the must-run condition, but you can utilize that generation that has the same capability to fulfill that.
If you
function.
replace it on site.
That's
I don't, well, we can take the questions in whatever sequence works for you. I don't recall seeing anywhere in the near-term action plan the identification of a generation resource to be located at the current Marshall Steam Station site. My recollection is correct, isn't it?
In the near-term action plan, I believe that's correct.
Yeah. So if that upgrade to the 230 kV line needs to be constructed, how long will it take?
Yeah, so we do have a project with a specific project number in our transmission additions plan for DEC. And the date at which that's projected to be in service, I believe, is out at the 2030 timeframe.
Your current project planning identifies that transmission upgrade as being available in 2030?
That's correct. But that could accelerate. They're looking at different options with respect to building a temporary line and building it, basically rebuilding what's in place or using an alternate route for another line. So,
say more about a temporary line. What is that? It's not the shoe flies that that there's been some discussion about, is it? That's not what you're talking about, is it?
shoe fly is more of a short
Right.
temporary line.
So
But
what is
it's-
this kind
it's
of
a longer-
temporary line?
It's a longer temporary line.
It-
And it would
it-
be built in parallel with the existing line such that you could take a length of section out of the existing line, upgrade it, rebuild it, and then move on down the line.
Built in the existing right-of-way?
That's correct.
Okay. When I look at the list of projects on table P2, the project you just described is not on that list, is it? Under some different name?
That's correct.
Okay.
I'm subject to check. Let me check.
Take a look at P2. I was not able to identify it from the names of the projects on P2. And if it has a different name in that exhibit, you can tell me.
Yeah, that's correct. It's not in the P2 list.
But it is an identified project. It's not yet approved.
So it's in the transmission additions plan. It's in the Copperleaf capital evaluation tool as well. Whether it's gone to the next gate, project gate, I'm not aware.
What would be the next gate?
It'd be the study phase.
And if, I understand that project right now projects 2030. If you wanted to accelerate that again, getting back to my original question, to have that project completed in time for a retirement of Marshall 1 and 2 by end of 2028, when would the approval need to occur and when would you need to start construction?
Right. So I don't know the specifics, all the specifics around that project, other than they're looking at options with respect to the temporary line and a different route where we already have right of way. So I don't know when they would need to start in order to make a 2028 date.
Do you know how long the construction would take if you had to build a new line in the existing right of way?
Just speculating, it would take quite a bit of time, but I don't know the project duration. I would have to ask the project manager what the duration is.
What I'm really struggling for is, are we out of time already in order to get the 2028 retirement of Marshall 1 and 2?
Yeah, no, I wouldn't say we're out of time already. I mean, there's ways we can accelerate with, multiple crews, et cetera, to speed up the construction.
But I take it you wouldn't try to invoke any of those accelerating steps until you first decide on whether you're going to put replacement generation
That's
at
correct.
Marshall 1 and 2. When will that decision be made?
I don't know.
Could battery storage located at Marshall 1 and 2 and connected at the same interconnection point serve the reliability need that otherwise occasions this upgrade?
Yeah. So two issues with battery storage. One is the charging would exacerbate the condition.
Sure.
Right? So that would be like adding load at Marshall as they were charging. So you'd have to consider that. The other thing is we have had periods where we've had at least 16 hours where the load level's been above such that you needed that generation online in order to be single contingency proof. And so I don't see a 4-hour or 6-hour battery even being a potential solution.
Battery's not an option.
Not under the current state, no.
What other options would there be?
One viable option would be CT, for example, that could run for long durations if needed. I don't know if there's space or topology or geography qualifies for an SMR, which wouldn't be done by 2028, of course. But I mean, right now, I would say CT is the only viable option with respect to replacing the capability for the must-run condition.
Okay. I think I know where we are. I appreciate it. One other question for you is just a curiosity question. You were asked several questions on cross-examination, and you referred to the planning process and mentioned that the public staff had initiated a public policy study request to the Transmission Planning Collaborative. I don't recall when that was initiated, but I seem to recall that it was delivered. The results of the study were delivered about this time a year ago. Is my memory correct?
I believe the report was posted this year. The final report was posted this year around the June timeframe because we were going to include the results in the carbon plan. It's one of the things the commission had requested us consider in the carbon plan, and the final report hadn't been generated, and so we weren't able to include those results in the carbon plan.
Am I recalling an earlier draft report, perhaps in the fall of 2021? Was there an earlier initial draft?
So yes, we put a draft of preliminary results out, and so that may be what you're recalling.
Well, I'll tell you where I'm going. It's a curiosity question, but it came up in cross-examination, so I wanted to explore it. It's my recollection that at least that it's probably the earlier draft that I saw, that the results of that public policy study requested by the public staff did not indicate a need for any of the red zone upgrades. Is my recollection on that correct?
So subject to check, I thought there were lines that were identified, subject to check. I thought there were lines identified. I may be thinking about the transitional cluster study though. But once again, and this is what I indicated to the interveners questioning, is that we need to transition to more of a generator interconnection like study associated with the TPC studies. And also, if I remember correctly in that study, you were kind of assuming everything was able to be sequenced to be interconnected in 1 year almost. And so it didn't really look at that sequence of interconnecting resources as well. But I think the main culprit would be associated with you need to have that study being performed like a generator interconnection study in order to get viable results.
And it wasn't done that way. It
That's
was
correct.
done as a sort of like a
screening.
A fixed point in time. If the resource portfolio looked like this at this fixed point in time, what would the transmission grid need to look like?
That's correct.
Okay. Since neither you nor I have the document in front of us right now, as I say, it was a curiosity question about the red zone, and I'll leave it alone for now. I don't need to know any more about it. Thank you.
You're welcome.
Commissioner Duffley.
See, good afternoon. So I have a curiosity question based on Commissioner Clodfelter's questions regarding the generation replacement process. And my question, it relates to how far away can a generation unit be away from the switch yard? Like how many miles does it need to be right next to the switch yard?
So there, a couple of requirements associated with generation replacement. One is you have to connect to the same electrical point of interconnection. The existing generation owner basically provides the replacement generation. And I lost my train of thought, but I had a third point. I can't remember my third point now. Sorry.
Well, I'll ask again, how far away, and maybe this will trigger it.
Yeah.
How far away does a generating unit need to be
thank you.
away from the switch yard?
That did trigger. So you can't have a material impact to the transmission system. That's the whole purpose of the independent entities study associated with the replacement generation.
So you have to spell it out a little bit further for me. So my question is related to reliability and any type of radial lines that you might have to build. Let's say there's the option that a generating facility may want to locate 10 miles away from the switch yard. And is that possible? And does that cause any type of reliability issues or concerns?
Yeah, I mean, you introduce that vulnerability with respect to storms, et cetera. Taking out that, I guess, what a long span, multi-span bus to get that generator connected to the same switch yard. So yes, it would introduce reliability issues. But once again, the generation replacement coordinator would have to study and evaluate to make sure it's meeting the criteria and to make sure there's no material impact to the transmission system associated with that replacement resource.
But could you provide redundancy in those lines to reduce that risk, or no?
I mean, eventually it becomes a new switch yard, right? That you're connecting one to the next. And so, with that, it wouldn't meet the requirements that FERC has approved for our generation replacement process.
Okay, thank you for that. So on page 5, you mentioned SRTEP, which is, for the record, the Southeastern Regional Transmission Planning Process. And I just wanted to go over a little bit of the history, help me remember the history of Order 1000. And if I remember correctly, FERC stated that the North Carolina Transmission Planning Collaborative would not be an acceptable regional planning entity. And the question, and Duke ultimately joined SRTEP for that compliance filing. My question to you is, did you consider the South Carolina Regional Transmission Organization, or
Yeah, SCRTP.
Thank
Yes.
you. Did you consider joining that regional transmission planning organization, and why did you choose, or why did the company choose SRTEP?
Yeah, so I don't know all the history behind the evolution of the regional transmission planning groups. Yeah. Subject to check. My recollection is that the South Carolina companies were asked to join SRTEP, and they said, no, we're forming our own regional transmission planning group for whatever reasons. And that's how the evolution occurred. Duke being in SRTEP, and then the South Carolina companies having their own regional transmission planning group.
Okay, so So it kind of evolved all at the same time because CERTEP had already been created pursuant to 890
Right.
compliance filing. And so the South Carolina group formed at the same time that your companies joined CERTEP.
For Order 1000 compliance.
Correct.
Yeah.
Okay, thank you. And then on page 34, you mentioned other regional working groups. And you mentioned the Carolinas Transmission Coordination Arrangement.
Yes.
And could you, and I think on the direct, on your direct testimony, you stated that you did not attend these, any type of meetings, but if you can you provide more information about this working group? Like how many times does it meet? Or does it meet on an annual basis or quarterly basis? Or do they only meet when certain issues pop up between North Carolina and South Carolina?
Yeah, I honestly don't know the answer to the frequency of meetings. I know that they conduct reliability studies, and that's primarily it. I think Commissioner Claude Pelter asked me that question on direct associated with, are they a direct parallel associated with the NCTPC? And the best of my recollection is they've only performed reliability studies.
Okay, thank you.
All right, at this point, we are going to recess for lunch. We'll go off the record. We'll be back on the record at 1:30. Questions from commissioners? And you've completed your questions. Let me see if Commissioner Hughes has questions.
Yes, thank you. I want to ask a few questions about an example because that's how I understand things a little bit better when I'm thinking about something. Let's take an 80 meg state-of-the-art solar plus storage facility. Okay, just you got it for your birthday. You unwrap it. This is a question for you on the transmission side. Can you think of a place to put it where it would just be an ideal asset today? So what you'd be thinking about is I'm going to go ahead and put it here, and after I do it, my life as head of transmission is going to be easier. It's going to be better. Transmission system is going to be stronger, rather than what's it just going to cost to put it there.
Right. So today, assuming red zone projects or without?
Today.
Today, without. So it's a good question, and you got to consider the different aspects associated with how that resource is going to function. So for battery storage coupled with the solar, you're going to have to consider charging. I believe I stated to the public staff the other day that with respect to that charging, we're not going to study battery storage for charging on peak because it doesn't really make sense. That you want that energy to be delivering to load to serve customer demand on peak. And from a carbon perspective, displacing coal, if you had coal on during that peak. So, from a transmission perspective, I don't know that I would see solar plus storage as a transmission asset, i.e. deferring transmission. So I don't think I would be placing it to utilize it in that manner. I would be utilizing it more so to be able to serve load. So if I could get decent land availability for the solar, ideally I'd place it near a load center. You limit losses, your battery's going to be discharging at the peak to serve that load center. So ideally that's the location that I would see if I had the land associated with the solar needs.
Does it make a difference if it can be charged from the grid? I'm thinking it because we're kind of settled on that as being, I think, during this hearing as the ideal. So it can get charged from the grid, or does that make a difference?
Yes, with respect to grid charging, once again, we'll be studying that grid charging and making sure that the transmission system can support that. So yeah, you would have to look at where that energy, if it weren't provided by solar, i.e. cloudy days, rainy days, snowy days, if it wasn't provided by the local solar, then where would that energy come from?
I hate to be too hypothetical, but I'm going to go ahead and say, you're given this, it's your birthday gift. You have to install it within the next year. Can you think of a place on the transmission grid that would be your ideal place, or can you think of what you would do to find out where that ideal place is? So it's a question at least a little bit more on the benefit side than just how can I minimize my costs? Can you, what would you do to just go ahead and find that ideal spot where the asset would be somewhat of a benefit?
Once again, if the land availability was there, it would be near a well-connected 230 substation that was near a load center.
Okay. And I mean, would you have to do any more? We heard that with it being able to be charged by the grid and going out, it might require actual modeling as a source, what kind of modeling would you have to do? Would you have to do a lot of modeling to kind of confirm that's a good spot?
Yes, I mean, we'd have to look at it as, once again, a load, but not at the peak. I think in our practice, we've got some load levels defined at or below this load level, it can charge, or it'll be studied for charging. And then the discharge at peak, so you'd look at discharging from that facility during winter peak. You'd look at discharging from that facility probably during solar peak, as well as output at solar peak, probably output at net demand peak.
Okay. So, I'm assuming that that's all done through some sort of power flow modeling, and do developers have the same access to that same kind of modeling as you had? I don't know if you were here when I asked
Yes.
a question about what's the single thing that might speed up the interconnect. So if we wanted developers to go and find that same place that you picked, do they have all the same information that you have?
Yes, so I know they have access to like the DICEA study, for example, this time around, or past generator interconnection studies. I know that we would post those studies. I think this was true for the transitional cluster study. We would post those study cases where the developer or anyone, a consultant, whoever could access those cases. And they should be able to take those and replicate the results. I heard what Mr. Norris said, but they should be able to take those cases and replicate the results.
But
They would need to have the PowerGem Terra application, which is what we use. But having that and having those cases, they should be able to replicate the results.
But if they didn't want to, I'm sorry to push, but if they didn't want to replicate and they just wanted to duplicate and do it, be able to go do it themselves. So they were identifying on their own, kind of. So when you put it through the study, there's no surprises.
Right. Go ahead.
Well, I was going to say, I think you're hitting on a really interesting conundrum that if a particular location on the grid is flagged as a great location, then lots of projects are going to want to site there. So then when you end up in a cluster, suddenly you have a lot of projects right there, and that spot that used to look great probably won't look so great anymore. And so that's why it's very tricky to provide that kind of guidance as to optimal placement in the way that you're suggesting, because as soon as you make that announcement, then it's probably no longer an optimal spot because you can exceed the capability there easily. It's a difficult problem.
And so we're stuck. We can't do what everyone would agree would make the most sense.
In the past, that guidance has been provided since at least 2018, as I recall, it's been provided through red zone maps. And that has changed some over time. It's expanded some over time, but we have provided that guidance with respect to if you choose to locate in this area, then you're probably going to incur network upgrades, and it may take a while to get those network upgrades in service. Now, that's not to say if you request interconnection outside of that red zone, there won't be network upgrades. In fact, I've stated in testimony there probably will be some network upgrades. And it's dependent on volume and location as to what those upgrades are.
And I know I appreciate that. I know I'm simplifying it, but it does seem like those maps might not be enough to really actually find where is going to be the ideal setting. The follow-up is getting back to this price signal question. So this would seem like it would be a facility that we would support more than some of the other facilities that we've talked about, or you could imagine that we're going to be in places not nearly as beneficial. Do we send the right price signal to that kind of project? Is the RFP process benefit that type of project?
I think if we ever identified a particular area of the system where we felt we really needed that power, then we could direct a general area. I think that there are examples in other states where they have local RFPs in particular to meet particular needs. But in the case of solar, usually we're driven so much by land availability and trying to have the right geography, topography, and just the amount of area that I don't think that predetermining specific locations of where solar would be optimal on the grid is very helpful because it's so dependent on the land availability, really.
Okay. Well, I won't ask you to go through the same exercise with just a standalone battery where land wasn't quite as much of an issue, but you can think about what the answers would be where we took land out of the equation. But it really helps me to kind of figure out where we're going. That's all.
Okay. Commissioner McKissick.
Actually, I think the panel's done a great job in responding to questions I had in the back of my mind, particularly as related to public staff issues. So I don't have any further questions.
All right. Commissioner Kimmerite.
Yes, good afternoon. Ms. Barber, I've got a couple of questions related, I think, to your statement on page 6 that you already quoted or read on line 15, which states, to date, these red zone upgrades have created insurmountable cost hurdles for developers of 1 or 2 projects being asked to bear the upfront costs, the upfront burden of that cost. And so my question's going to relate to that, and then also some information that you provided to CPSA's attorney in response to his questions. But for future solar procurements after the 2022 solar procurement, my understanding is that there would be potentially 2 ways to allocate the transmission costs that would be that a generator would trigger for those transmission upgrades. And the first one you, I think, explained in response to questions would be that in the bid evaluation process in the solar procurement, that the costs would be allocated. The costs that were assigned to the generator and DICES would be allocated in the bid evaluation process. Correct?
Correct.
Yes. And then the second possible way that I don't think you talked about, but I'd just like to see if this is correct, is that there would be the potential that the generators would be responsible for paying for those costs themselves. They wouldn't just be allocated, but the costs that are assigned in DICES, the generators would have to pay for in the solar procurement. Is that another way that it could be handled?
Correct.
Okay. And then I guess in response to the statement that you made on page 6, and then we heard testimony that about 3,500 or 3,600 megawatts of projects that have bid into the 2022 solar procurement are located in the red zone area. And I recognize that you said that some of the projects may drop out of DICES before phase 2 of DICES. So that number is not certain for sure. But with this greater number of megawatts in projects, have you done any analysis about whether these projects now would be able to pay for their network upgrade costs? Because those large costs would be shared among a greater number of projects, or at least a greater number of megawatts.
I have not done an evaluation to that effect. I think we'll have to wait for the DICES phase 1 results before we'll see how those costs are spread over the generators that are currently in this cluster. I think I'm missing the other part of your question.
Yeah, so that is my question. So after you look at the results, is that something that you will be considering, or is that an analysis that will be performed?
So I don't know that we currently have any other mechanism to distribute those costs that are triggered, except what's designed through the interconnection process or through proactive transmission planning. So I think those are really the 2 avenues that are available to us. And the reason that we are recommending moving forward with the red zone upgrades is because that brings us to a scenario where ultimately the costs are spread over a much larger swath of projects, and we don't fall into the same pattern of costs falling to not enough megawatts and not moving forward, costs falling to not enough megawatts and not moving forward. And so that is as I understand it, avenue available to us today to move these forward. And over time, they will be spread over, many megawatts, but today we don't have perfect foresight as to how many exactly megawatts there will be.
Yeah, and that's helpful. I think the one thing that I would like some clarification about is that if the red zone upgrades are approved by the NCTPC as the public policy projects, if that were to occur, then they would not be included in the base plan or the baseline. And so then they would not be allocated among the projects in the solar procurements. So I'm seeing a little bit of a disconnect here. And so maybe I'm misunderstanding it.
Let me see if I understand your question correctly. So if they're approved by the NCTPC and they move forward, for the 22 procurement, it was our understanding from the commission's order that they should be part of the evaluation for the 22 RFP. I think that how they're incorporated into the evaluation for 23 and beyond is still to be decided.
Right.
And so it might be that if they are approved and they're in the baseline for a 23 DICES, that there might be something to design in the RFP such that it's not just a 0 assigned to those red zone projects, but that there's some cost reflected in the evaluation process to recognize that there was a transmission cost associated with it. Is that what you mean?
That's very helpful to understand that there might be a mechanism for some sort of allocation, even if they're approved by the NCTPC. So thank you.
That would be
That's
new
very-
territory for
Right.
us, but I think there's certainly much that we still have to design for our next RFP.
Okay, thank you.
All right. Any other questions, commissioners? You may.
Is it possible that the rankings for the RFP could be really different depending on whether you take into consideration, I think it is, but whether you take into consideration the transmission costs? So if we take that off the table and just rank the prices, and then you have that ranking, and then you add the transmission and you have a different ranking, which ranking will you use? Just the second ranking?
The way the 2022 solar procurement is designed is that we would use the ranking with transmission costs included.
Okay. But if had been a decision midstream or to actually go ahead with the red zone, then the result of the RFP is we are no longer taking in the low cost projects by the time they get connected.
It would have, potentially changed the ranking because projects located in the red zone would, if the red zone upgrades were already approved at this point in time and had been approved prior to this RFP, if they were already included in our local transmission plan, then we would not be assigning those costs to generators in DICES. And so to that extent, it would have an impact on what the ultimate costs are assigned to those generators, and it would theoretically change the ranking.
I mean, it seems like that if that's the case, the outcome is not going to be the least cost for customers, because they would be paying the socialized red zone costs, and then now they are no longer getting what competition did for driving down the price, because the ranking is based on so customers, it would seem like are not going to get the actual least cost set of projects.
So I mean, if I put a developer hat on and I know that transmission cost is not an obstacle bidding in a project in the red zone, my bid's probably going to be lower to ensure it's competitive and it wins.
I'd also add that things were moving very quickly to get the 22 RFP off.
No, I understand.
Well, I mean, this is, if the red zone upgrades are approved by NCTPC and sort of ready for the baseline in 23, all of these future projects will show that as part of their baseline. So it's not a continual
Right, it's just
issue necessarily. It's sort of a limited slice of this 22 RFP wouldn't have had the foresight of knowing that those upgrades were going to be paid.
Yeah, that makes sense. Okay, thanks.
Okay, so I just have a few to follow up on the discussion that you all have been having on the red zone projects as well as procurements. Because I thought I'm just confused at this point, and I'm hoping I cannot be confused by the time I get out of this hearing room, and that's my plan. So we all
I
know
hope we can help.
Okay. So the way I understand what the companies are asking of this commission in this proceeding is that the companies want us to indicate that the red zone projects are needed to enable the solar targets identified in the portfolios that are included in the carbon plan. Do I understand the company's request correctly?
That's, excuse me, that's correct. We're requesting acknowledgement that the red zone projects are needed to be able to execute the carbon plan.
And so if we give the if the commission gives the companies that acknowledgement, then what?
As stated with respect to the NCTPC process, we've got to present the supplemental studies to the TAG, and then end of the year, present the local transmission plan draft. The commission order should coincide with around the time the NCTPC publishes a final report. And so, we would hope to have that commission acknowledgement to use to bolster that, yes, these need to be in the local transmission plan. Because until that final report's published online, they're not in the local transmission plan.
So if they're in the local transmission plan, assuming that the NCTPC votes to include them in the local transmission plan, how does the company act on that?
If they're in the local transmission plan, they're considered part of our transmission additions plan at that point.
And so
they
the
become-
company, I'm sorry, I didn't mean to interrupt you.
No worries.
Okay.
They become projects as part of the transmission additions plan.
So the company would construct, and it would be capital investment, just like any other capital investment the company makes.
That's correct.
Okay. Before you all came back on rebuttal, I thought I understood your testimony to be that the if the company, if the commission were to give you this acknowledgement and the companies were successful in convincing the OSC, is that right? To vote to approve the projects, the projects would be included in the local transmission plan or the baseline for the 2022 procurement. Did I misunderstand that?
So they would become part of the baseline for the 2023
Okay. So
DICES.
Okay.
There might be
2023. So for the next DICES window, is that right?
That's correct.
Okay.
I think Ms. Barber has a clarifying.
Okay. Please, Ms. Farver.
Correct me if I'm wrong. That when a transmission upgrade is part of the local transmission plan, it would, the cost of that upgrade would then not be assigned to a generator in their ultimate interconnection agreement. And so I think there's a timing question here of when exactly that becomes official in the transmission plan. I don't know if it would be in time for a phase 2 cost estimate to assign that cost elsewhere, or if it would still be on the generator. But by the time the interconnection agreement is signed in Q1 early 2024, it may have become a contingent facility at that point, in which case the cost would not be assigned to the generator in the ultimate interconnection agreement.
Okay.
Mr. Roberts, please correct me if I've stated that.
Yeah, so, I mean, all that sounded correct in a normal world, but we're not in a normal world. And so the way the 2022 procurement is structured, it seems like we would have to move forward with evaluating these projects, and the cost included would consider the red zone expansion plan projects.
Okay. So,
That,
okay, so,
So I may have misspoken in that the costs won't be assigned elsewhere until the 2023 DICES begins.
right, that's my understanding.
so then all of those red zone dependent projects that that are participating in 2022, it's likely that they're not going to move forward unless,
It will depend on how many of these upgrades an individual project hits and what the allocation is. But
so there's a chance that before, I'm trying to work out timing here. So there's a chance that if a project in the 2022, if a bid in the 2022 procurement is dependent on a red zone project, that it could be assigned costs associated with that red zone project. If you all haven't been able to add the red zone projects to the baseline,
I think it,
given the timing of our order and your ability to get it through.
I think it is a question of timing, as to when the official approval comes, when the cost estimates are provided, and when the reports and the ultimate interconnection agreement is executed.
Okay. I'm just trying to figure out, we watched CPRE Tranche 3 fall apart. That's my word, just a simple shorthand. Then we kind of watched the transitional cluster. You know, we all know what happened with the transitional cluster. And then are we going to say the same thing happen with 2022 if we were to, well, don't even answer that question. It's just a sort of thought that I have in my mind. So I appreciate your hanging in there and answering these questions. I'm just trying to get through all of this, and you've responded to questions from commissioners about, I think Commissioner Kimwright said post 2022, there'd be two ways to deal with, again, these were my words, deal with upgrade costs. Upgrade costs, specifically the red zones, and we could, and you mentioned including them in the bid evaluation process so that each bid is allocated, a certain percentage of upgrade costs that it triggers. Or the generator could be responsible for paying whatever percentage of the upgrade costs it triggers. Did I understand that correctly?
I think that was a good summary.
Okay. But why is that just post 22? I mean, couldn't that still happen in the 2022 procurement? Couldn't that same approach, either of those two options?
I believe it would require the commission changing the stance that it shouldn't be included in the baseline. So we've been designing the 22 RFP based on the commission's order that these upgrades would not be in that baseline. And so I imagine that would have to change in order to change anything to the 22 RFP.
Okay, and I guess I didn't understand Commissioner Kimmeright's question to be assuming the projects were included in the baseline. I just assumed, was that your question? Okay, I understood her question to be, how are we going to deal with network upgrade costs going forward? Because, I guess my question at this point is, we've been using the word allocated, and probably the conflation here is mine. We could allocate costs to bids for purposes of determining their competitiveness. That's kind of what Commissioner Hughes was getting to. Or we can ultimately allocate costs. And in certain respects, we've been through this in many different proceedings now where we understand at the federal level, costs are allocated. When we're talking about federal jurisdictional costs, they're allocated in accordance with the company's oaths on file with the federal government. But there are also costs, there are state jurisdictional costs that aren't subject to that federal allocation process that's established at the federal level. Do I understand that correctly? And do I understand that costs, let me ask a non-compound question. Do I understand that we've been talking about that costs could be allocated either to a bid for evaluation competitiveness purposes, or costs can be allocated to the generator for payment purposes. I'm just talking about, we can
Yeah.
use that term in one of two ways.
Yes,
Okay.
I agree. We've been talking about it in both, that sometimes we're talking about allocation just in the bid evaluation.
Right.
And sometimes we've been talking about allocation in terms of assigning that cost to the generator for them to pay in
For
order
them
to
to
interconnect.
ultimately pay. And I'm sorry, I spoke over you. Let me, okay. I'm sorry, Joanne. Okay, so going forward, we just need to be careful when we use the word allocation. If we're talking about allocating the bid for the purposes of determining its competitiveness, or allocating to the ultimate payer. My question for this panel is, so if we give the company what it wants, what it's requested on the red zone, which is an acknowledgement that they're needed to move towards the carbon plan obligation, 951 obligations the company now has, does the company take from that any implications, or does the company become obligated in any way with respect to then how it recovers those costs? Meaning then is it obligated to recover those costs from its ratepayers, or could it turn around and devise a cost allocation scheme or paradigm that could involve recovery from generators? A direct assignment approach.
Yeah, I don't know of any cost allocation methodology that is currently in place
Okay.
with respect to assigning those to a generator after they're approved and in the transmission additions plan, not associated with a specific generator interconnection.
Yeah, I'm not aware of a different way that we could assign those costs. And that's probably a legal question or legal interpretation as to, is there some other mechanism for cost allocation aside from the generator or through the local transmission plan? I don't know. I'd want to check with FERC attorneys and others.
Okay, so I'll ask my question one more time. I understand what each of you is saying. I'll ask it one more time because my question wasn't clear. If we approve, or if we acknowledge that the red zone projects are needed, and then the company moves forward with the NCTPC process, gets the approval it needs there, and then includes includes those transmission projects in its transmission addition plan, and ultimately builds them, is there anything keeping the company from recovering, if it's directed to do so by the commission, recovering certain of those costs from generators?
I think that's a legal question that I don't know the answer
Okay.
to.
Okay, that's fair. That's fair. Has the company given thought to how if we move forward with the red zone projects as the company has requested and is planning to do based on testimony y'all provided and in the carbon plan itself, how can the companies and therefore the commission be certain that customers are getting the most competitively priced solar that there is? And by competitively priced, I mean taking into account all of the costs that those specific facilities are imposing on the network.
As a hypothetical, I think there's probably an opportunity in future RFPs to include a piece of the evaluation to take this into account. I don't have a proposal or details worked out today as to what that would look like, but I think that is something that could be designed for and included in an RFP evaluation.
So post 2022.
Yes.
Okay. So 2022, the plan would be for the company, again, make sure I'm clear, the plan would be, or the company's plans or proposal is that, assuming again, the commission acknowledges they get through the NCTPC process, while bids may be allocated in the bid evaluation process, percentages of those upgrade costs that the bid triggered, that those costs ultimately are not going to be collected from the generator, but they would rather be collected from ratepayers at large.
If they are approved at the time, then yes, the assumption would be they would not be paid by the generator.
And I understand the timing issue, assuming the timing works out such that they could be included in part of the 2022 process.
I think that's right.
Okay. Okay, we haven't talked much about the solar reference cost. In fact, I'm not sure if it's been brought up. I don't think an intervener has brought it up. And I'm just curious, and if you're not the panel to address this, y'all don't hesitate to let me know. In the CPRE tranches, pursuant to the statute, the bids were subject to an avoided cost. We think of it as avoided cost threshold. The bids were evaluated for competitiveness against the then in effect avoided cost, and that included considering network upgrades in conjunction with the cost of the output of the facility. And so CPRE actually kind of did, in my mind, what I've heard you testifying to, Mr. Roberts, and that it considered transmission costs and generation costs together, at least sort of in my simple mind. We are now we're looking beyond CPRE to this 2022 procurement and then future procurements that the companies will have to conduct to comply with their obligations under the legislation. And, we have been presented with this concept of the solar reference cost. And help me understand how the solar reference cost will function will function like the avoided cost, because with the avoided cost threshold, we could have some confidence and a pretty high level of confidence that ratepayers were protected or were getting a most competitively priced solar output. Are we there with the solar reference cost?
Subject to my colleagues on the modeling panel's expertise, I think that the solar reference cost is a good mechanism for the world that we're in now. We're using the best information we have available to create that forecasted cost, and there is a transmission cost expectation built into that solar reference cost. And so what we designed in the 22 RFP was a mechanism to check and adjust in flight, essentially. So by having this deviation from the solar reference cost leading to a change in the volume potentially, that was our way to check and adjust when we were sort of in real time.
Okay. And there is also the downward bid adjustment opportunity in the 2022 procurement. And can you help us understand the function of that? What does the company expect to see as a result of that part of the process?
Do you mean the bid refresh in April?
Yes, the bid refresh.
That was an important consideration in this RFP because there was a lot of uncertainty about what was going to happen with the tax incentives. And so we knew there was a decent chance something would change, but we didn't know when or how it would change. And so this essentially allows an opportunity for bidders to sharpen their pencils and come back with a more competitive price if they're able. They don't have to, but it does offer that opportunity. And so I think that's really helpful for customers to make sure that they're getting the best offers available in the RFP.
And we anticipate, let me ask the question this way. Do the companies anticipate that by the time the bid refresh period opens, window of time opens, that there will be sufficient understanding about the tax credits and availability of the tax credits, that those can be, that revenue can be taken into consideration for bid refresh purposes?
It is unclear to me what level of detail we'll have from the IRS at that point in time.
Okay.
But certainly the more time that goes on, the more clarity we should have about how those benefits can be achieved.
In my mind, that those are critical benefits that should inure to ratepayers. So how do we need to move that bid refresh window to ensure that the bid refresh process can can sort of put some pressure on to?
I think the problem we run into is there's never a perfect time. And so if we delay this, there will be other uncertainties. We specifically designed the 22 RFP to align with all of these very prescriptive dates in the DICES process. And so pushing back the bid refresh window, we pushed it back as far as we thought we could by having it be in early April, because we're trying to announce the winners contemporaneous with the phase 2 results. And then there's a very prescriptive window for interconnection about needing a signed offtake agreement to keep moving forward. So we're stuck between these very set dates for the interconnection process. So I don't know that we would have wiggle room to change the bid refresh date without causing a lot of disruption for the rest of the evaluation.
Okay. Okay, Mr. Roberts, did you have a chance to review Exhibit D to the CPSA comments that were filed in this docket?
I may have, but I don't recall Exhibit
Okay.
D to see.
I asked Mr. Norris about them yesterday. I think it was yesterday. They, it's an exhibit that was prepared on behalf of CPSA, and Mr. Norris testified that Cypress Creek Renewables had been involved in the development of the analysis. And it basically is a GIS analysis of acreage in DEP's and DEC's service areas in both North and South Carolina. And it identifies these clusters of viable, acreage for solar development. Do y'all have a copy you can put in front of them, please?
Thought I may have a copy of it.
And if you haven't reviewed this or had an extensive amount of time to think about it, I'll keep my questions very brief.
What was this from again?
I can recall. It's a map with like the number 6 zone in
Yeah.
DEC.
Yeah.
Yeah.
You remember this? I'm hoping y'all's council can pull something out of the box over there. So my question for you all is this: assuming you've looked at it and here comes your counsel, but do you have any thoughts about transmission, the state of the transmission system in these areas? I mean, other than obviously the red zones that are located here.
Right. So number 3 includes a red zone itself. Number 2, that's where we were talking about the same corridor as the offshore wind transmission. And so, I mean, there's probably some capability there, but it probably won't be long before 115 kV line will show overloaded. So you'll probably run into a red zone there being created before too long, looking at the DICES. Number 5 is red zone. Number 6 is red zone. Number 4 is red zone. So that leaves number 1. And I think topology and land availability is an issue in the number 1 region.
Okay. Okay. The sort of answered my questions about transmission availability or state of the transmission system. But if we think about on a going forward basis, integrating transmission planning with generation planning as the companies grapple with the generation they're going to have to bring online, is this a way to start that process, looking at acreage that's suitable for solar development and then identifying, figuring out what the transmission system looks like in those locations? I'm just trying to get a sense of how to distill your recommendation of integrating planning for for generation and transmission into some action items or some concrete steps that we can think about.
Right. So, I mean, the one thing that we were able to rely on with respect to knowing the red zone projects would be used and useful and allow us to execute this carbon plan are the prior generator interconnection requests. So we're not going to have that going forward, right? We have the 2022 DICES, which has 5,000 megawatts, 4,900 in the red zone. So we had the 2022 DICES that informs us a little bit too with respect to a lot of solar and DC and DP wishing to interconnect. I mean, as far as studying it from a zonal approach, and then I'm forgetting what Mr. Norris recommended, but would procuring from a zonal approach, is that what you're asking? Would that
No, I'm
benefit?
just, I mean, that's, one place where you could go if you start with the assumption that should we be looking at area where there's suitable land for solar development? Because one of the things that the commission has been hearing is there's a limit on suitable land, and the most suitable land for solar development is in the red zones. That's why they're all there, and that's why they continue to show up there.
Right.
So sort of getting beyond the red zone, looking out into the future, should we start with where is land suitable for solar development, and then identify the most efficient places to locate on the transmission system, sort of when you overlay transmission system with that land?
Yeah, I mean, we can look at kind of like with the NCTPC wind study and look at, different capabilities of injection into the transmission system at various points. And then overlay that injection capability with the land availability with the map. I forget what figure it is, but there's a figure in the testimony that shows the high solar viability from a land perspective, parcel perspective. And so you could overlay that injection capability with that land availability.
Okay. Okay. And then identify locations on the grid that would be conducive to lower cost solar development when you consider both the cost of generation and the cost of the transmission.
Right. I mean, ultimately it gets down to the developer saying have a land lease at that area, whatever. I mean, they would have to select and bid in that location and megawatt size to take advantage of that screening, so to speak.
Okay.
I don't know the proper way to make that happen.
Okay. All right. I think that's all for me. Just make sure. Mr. Roberts, I just want to make sure I'm clear on one thing. Tyler Norris yesterday testified that developers couldn't replicate the power flow modeling. And you just testified in response to one of the commissioners that you didn't understand why developers couldn't replicate.
Right.
Is that what you were talking about? Were you talking
Yes.
about the power flow modeling?
Yes,
Okay.
he should be able to take the posted cases for the DICES or transitional cluster study and be able to replicate those results.
Okay. Assuming that they have some sort of.
It's called TARA, TARA.
Okay.
Application by PowerGem.
Okay. And is that an obscure piece of technology, or would it be a reasonable assumption that a sophisticated solar developer would have access to that?
If they have a little bit of power flow skills, transmission planning skills, they can probably use it or learn to use it.
Okay, understood. All right. I think that's all I have. Thank you both for responding to the question. Well, definitely has beat me, so definitely.
So can you remind me with respect to the 2022 DICES RFP, is it similar to the CPRE process where the bids that come in do not reflect paying for the network upgrade costs, but rather those network upgrade costs are assigned afterwards for bid ranking purposes?
We designed the 22 RFP slightly differently. So for the PPAs, there's what we've called a Part A and a Part B bid price. So Part A is just as CPRE was, that would include interconnection facilities, but not any system upgrades. Part B is an adder for what that developer would be seeking in dollars per megawatt hour per $1 million of system upgrades that are assigned, and that would be additive to their Part A price.
Okay, thank you. I do, and that is the two-part bid is before they know the assignment. Is that correct?
Right, and Part B was designed that it's per $1 million of upgrades, so that if it comes in at 5, then it's scaled. If it comes in at 10 million, then it's scaled.
Okay, thank you for that. And Mr. Roberts, do you remember my examination or questioning or however you want to say it, discussion with you about the hypothetical that even the hypothetical the other day was even if you did not have all of the generator interconnection requests for purposes of this hearing, Wood and Duke had to build 100% of the solar that Duke feels is needed to meet the carbon plan. Where did you state? Did you state that the red zone was an area that Duke would choose?
Yeah, I mean, once again, due to the land availability, parcel size, sorry. Due to the solar viability in that area, where we could have larger solar facilities per interconnection, I definitely believe the red zone would be the location that we would look to for putting these large solar facilities to meet the carbon plan.
Okay, thank you.
So it's obvious there's a little bit of confusion about exactly the specifics of the RFP. So I just want to make sure I understand it and that you two are at least in agreement that whether it's 4,900 we're sitting on these exciting 4,900 megs of bids, right? That we're all excited about. Was it clear to all of the bidders that they were going to pay their A bid plus some transmission costs no matter what?
So the Part B bid is for an evaluation to decide whether the utility will pay for the upgrades or whether the bidder will pay for the upgrades. And so this is explicitly written into the RFP document, and we had stakeholder meetings about that as well. So it should be well understood. This suggestion actually came from our independent evaluator as we were trying to ensure that it was least cost for the utility to pay for those network upgrades, as we did in CPRE. This seemed like the right mechanism and was their suggestion for how to verify whether it was more cost effective for customers for the bidder to pay for the upgrade or for the utility to pay for the upgrade.
But did I hear you in responding to Chair Mitchell say that under the mechanism we have, there's no permitting option B, that at least in the red zone, that for this procurement, that's where I was confused. And but for this procurement, what's going to happen is there's going to be an option C, which is their bid and the actual transmission upgrades that are incurred with whoever is left in the accepted bids.
Can you repeat that? Because I'm not sure I understood your question.
So somebody bid, they have a bid, that's A. Bid B is essentially assuming that you pay for the red zone, it's socialized, so it's, right, and they know what it is. But I thought you said a moment ago that there's no cost allocation method that you have now available that they would actually pay B. They're actually going to pay another price, which is their bid plus the actual upgrade cost, even if they're in the red zone, because the red zone wasn't accepted before the RFP.
I think I understand. Oh,
Okay, yeah, I'm sorry.
I think I understand. So the part B is not a flat, millions of dollars. It's dollar per megawatt hour per $1 million of upgrades. So that bid, if it were in the red zone, and let's say it hit everything and had a very high price tag associated with it. So that slider bar would go up. So if it's $30 million of upgrades and it was a dollar per hour.
I'm with you on
adding
A and B, yeah, excuse me.
And so if the red zone upgrades are approved by NCTPC, and that all happens by, I think, May, when the phase 2 report would be issued, then for our evaluation, we would use that $30 million of network upgrades as we ranked that bid. But since their ultimate interconnection agreement would not have the $30 million in it, because it would get paid for in a different way, they would not have the part B as an adder. So if the 30 million went down to 1.
I misunderstood you. Okay,
Oh.
I understand. Okay, that makes sense. I thought you were saying that even if the red zone got approved in May, it doesn't matter because it wasn't made out that way in the RFP. That's what I thought you said. I misunderstood.
For
So-
the evaluation, that was kind of getting at that distinction between the evaluation.
No, okay, but for the cost allocation,
I think that's to be determined with the exact
Right.
timing.
but, and if we don't, okay, I just was misunderstood. And if red zone is not part of the final, then there is going to be this point C that is their bid A plus the actual costs of the red
It'll
zone.
be- Yes, I'm
Yeah.
sorry. B times whatever that cost is added to A.
Yeah.
Yeah.
Okay.
Questions? Go ahead.
Mr. Roberts, this may be a question for the long lead resources panel, but you're the transmission guy, and I just remembered that if I let you get away and then they refer the question back to you, I'm stumped. So
I'm on the reliability panel too. So.
Oh, that's right. But this is not a reliability issue, really. It's not a reliability issue. Let me just ask generally, do you have any understanding about the transmission pathway from that's being looked at from a landing point for offshore wind at Emerald Isle up to an injection point in Newbern? Do you know anything about the transmission pathway there?
Yes, I do.
Well, then let me ask you the question then. In the long lead resources panel direct testimony, we were told that one of the pathways that is being looked at is to land from Carolina Bay, to land it somewhere around Emerald Isle, and then to bring it up to Newbern for injection into the grid. And that look from the map I'm looking at, that looks to be about 70 kilometers of onshore transmission. Would that be an existing transmission right-of-way pathway that you'd upgrade? Would it be a greenfield transmission line? What would that pathway be?
Yes, sir. That would be new right away.
New right-of-way?
Yes.
And what would be the sizing on that potential transmission line?
Well, it'd be a 500 kV DC line.
500
direct
kV
current.
DC.
Yes.
I'm glad I asked you the question. Thank you, sir.
All right, questions on commission's questions? Start over here.
Okay, we're going to go out of order. This is Carrie Grunman from Walmart because I want to follow up on pretty much every commissioner's question to make sure that I feel like I understand everything we've just talked about transmission. So I think Commissioner Hughes clarified for me what happens if, for purposes of the 2022 solar procurement, if the NCTPC approves the inclusion of the red zone projects in your local plan, then any of those upgrade costs would be assigned for purposes of allocation to the generators, but would not be paid by the generators, but would instead be recovered from customers through some separate mechanism. Is that correct?
Very close.
Oh, I'm
Just
so
in the
close.
term,
Okay.
just in the term. And I think this is getting to that, using the term allocation, if we're talking about for evaluation of the RFP or for actually having the generator pay it.
So that's why I use the word assign versus allocate to try to differentiate. But I'm just saying if the NCTPC approves the red zone projects and they get added to the company's local plan, then generators will not pay those upgrade costs, but they would be assigned those costs when you evaluate them for competitiveness of the bids.
That sounds correct.
Okay. Now, if the NCTPC does not approve the projects by the time of the phase 2 study, then those generators will be assigned the costs of the interconnection and would be required to factor those into their bids.
They would be required to pay for those costs as part of their interconnection agreement. The bid design has this part B. And so they've already bid what is their adder per $1 million of network upgrades. And
What do they need to receive if they are assigned those costs for every $1 million? So how much more do they need to earn per megawatt hour if so many millions of dollars of cost are assigned to them?
That sounds right.
Okay. So now I think I understand. Now let's talk 2023. What happens if after the phase 2 interconnection requests are all signed for 2022, the NCTPC approves the red zone transmission projects? Then who pays for them?
So it would still be distributed as other transmission upgrades are. It would not be specifically assigned to those generators in the interconnection process. But I think what Commissioner Cameron was getting at is how do we account for that or acknowledge that in our ranking process?
Well, hold on. Let me come back to that because I just want to make sure I understand. So hypothetically, all of the red zone transmission upgrade costs could be triggered by the bids that were submitted in the 2022 solar procurement, correct?
Hypothetically.
So but it's also possible that some do not, but that in the 2023 procurement, new projects would get the benefit of upgrades that weren't triggered by the 2022, but that are subsequently included in the baseline for purposes of the 2023 procurement. Does that question make any sense? And I can try to reframe.
If you could repeat it, that would be helpful. I think I got lost in the details.
Me too. If the 2022 solar procurement bids trigger some, but not all, of the red zone upgrades, and let's just assume that those generators have to pay those costs, but then subsequently the NCTPC approves the entirety of the red zone project, then for purposes of 2023, do all of those projects, are they then going to be considered in the baseline for any bids that would be received by the company in 2023 solar procurements and beyond?
That's accurate. Once they're in the transmission plan or once they're assigned to a prior generator who has signed an interconnection agreement, then they would be in the baseline.
Okay.
Did I say that correctly?
That's correct.
So in the situation where I know I'm in sort of a hypothetical, but in a situation where they were not assigned to the generator, there is a possible situation where some red zone costs would flow through customers and some would be allocated directly to generators for purposes of who pays the cost, to be clear about my use of the word allocation.
I think this is tricky because ultimately customers pay for it either way.
I don't
because
disagree
the
with
bid
you.
price is changing literally as a lever of that.
Understood, but I'm just talking about the mechanism where they could be flowing. So we could see some transmission projects that ultimately make their way through base rates and others that make their way through increased PPA prices from third-party generators.
I think that is possible if these upgrades are, I guess, sort of established piecemeal. I think that's right.
And so in
All right,
some,
Ms. Grumman, I'm gonna reel you in here some.
Okay.
This is not cross-examination again, recognizing
no.
that commissioners have asked questions of the witnesses about the red zones and the panels. It's just not it wasn't carte blanche to ask any and all questions about it. So please remember to refer to a specific question that we've asked and ask a follow-up on that question. We cannot go through cross-examination of these witnesses on the general topic of the red zone and how those costs are going to be recovered or assigned or allocated or otherwise. So please limit your questions so that we finish this hearing this week. Thank you.
thank you, Chair Mitchell. No, I apologize. I was trying to understand. I was somewhat confused. I think those are all the questions that I had.
Can you hear me? That off. I have one question for you. In response to Commissioner Mitchell, or Chairwoman Mitchell's question, she was asking whether the companies understood that or anticipate by the time the bid refresh window opened, there would be sufficient understanding of the IRA's tax credits. Do you remember that line of questioning?
I recall that.
In establishing the refresh window and dealing with the uncertainty that led to that refresh window, was the tax credit the only issue, or was the tariff case also injecting some uncertainty into bids and understanding of the market, to your understanding?
I think there was also a hope that there would be more information about the tariff case, and so having more assurance or indication of where that would land might allow bidders an opportunity to move their bids downward as well.
Great, thank you.
Chair Mitchell, I would ask that the commission take judicial notice of Duke's T&D filing as required by commission rules for a performance-based regulation rate case for docket E2 sub 1300, which was filed August 3rd, 2022.
Did you identify the docket number?
I think I did, but let me do it again.
Okay.
Docket number E2 sub 1300, the supplemental information Duke provided following the technical conference, which was filed on August 3rd, 2022.
Okay. There being no objection to your request, the commission will take judicial notice.
Thank you. And following up on a couple, and I'm not going to reinvent the wheel here, but just following up on a couple of questions you got about cost recovery mechanism. DEP has already identified RZEP upgrade projects as capital costs that it will seek to recover in its proposed multi-year rate plan in docket number E2 sub 1300, correct?
That's my understanding.
And there are, would you agree, subject to check, 11 RZEP projects that Duke is going to seek cost recovery through its MYRP for in DEP?
Subject to check.
And the costs of those projects total, subject to check, would you agree, $212,345,684?
Subject to check, yes.
How many of those this is going to Commissioner Hughes's question on benefits, and I believe also Chair Mitchell asked about maximizing benefits for ratepayers of the RZEP upgrades. How many of those 11 projects have a cost-benefit ratio less than 1?
Objection, this is not the rate case, the PBR case. It's not relevant. It's one of the commissioner's questions.
To be fair, I did tie it to multiple different lines of questions from the commissioners who asked about ensuring benefits to ratepayers from the RZEP upgrades.
If
Yeah,
I'm,
I'm going to sustain the objection.
And sorry, let me back up. Last question, I believe. Tying this to multiple lines of questions that you got from commissioners on what happens if the NCTPC votes to include the RZEP projects in the local transmission plan. My question is, if the NCTPC votes not to include RZEP projects in the local transmission plan, will Duke still seek cost recovery through its upcoming multi-year rate plans?
So we'll still be seeking evaluation and approval of those RSEP projects through the NCTPC process, whatever new study, new evidence that would require. But I mean, I think there's, and interveners have stated there's ample evidence through multiple studies that these projects are needed to execute the carbon plan.
Was that a yes or a no to my question?
So your question, just to repeat, was what happens if the NCTPC does not?
No, it was
cover?
specifically, will those costs still be sought for recovery through a multi-year rate plan if the NCTPC votes not to include these projects in the local transmission plan?
Yeah, I would leave that up to the determination of the rates people. So.
Okay, thank you.
Go ahead.
Okay, thank you. Mr. Roberts, I'm gonna start with the easy one. I'll try to move quickly here. This is following up on questions by Commissioner Hughes and Chair Mitchell about the information that was provided to developers regarding interconnection studies. You recall that?
Yes.
Okay. And you testified that Duke provides the base cases used in interconnection studies to developers, and they can input those into Power Gem. Is that right?
My understanding is we provide the cases associated with the studies performed for the DICES, and that the person that retrieves those cases would need to have the Power Gem application called TARA, T-A-R-A, to be able to utilize those cases to reproduce results.
Okay. So when Duke does an interconnection study, it takes cases, it takes a baseline, and then it studies that baseline under various scenarios and contingencies, right? I'm sorry, contingencies, correct?
That's correct. We look at, and we provide that file as well, the contingency monitored element file.
So it's your position that Duke informs developers of exactly what contingencies and scenarios that it is studying in the interconnection process?
So subject to check, my understanding is that information in a file is provided.
Okay. Okay, would you agree that when Duke identifies an overload in an interconnection study, it does not tell developers what the magnitude of that overload is or what the contingencies or scenarios that triggered it are?
So the person utilizing those files and using the Power Gem tool, TARA, would need to have some knowledge of how to generate the DFACS file from TARA to be able to assess which elements are overloaded. And the line loading percentage, the check and see if the loading percentage was over 1%. That's just using the power flow numbers.
Okay, but Duke does not provide that information directly to developers. Is that right?
Well, the results would be provided in the transition cluster study or the DICES study results.
I was going to say the phase 1 report, I think, has the defects contribution of the generators.
Understood, but that the defects contribution is sort of the end result of a fairly complex analysis, isn't it?
It's the result of utilizing those cases that are posted once the study's completed.
All right, thank you. So Chair Mitchell and Commissioner Hughes, Commissioner Kemmerite asked a number of questions about the timing of the RFP relative to the red zone upgrades. So just to clarify, Duke's proposal is that the red zone upgrades would go into the local transmission plan around January of 2023 if they are approved by the TPC. Is that right?
That's about the time the final report would be posted with the red zone projects included if they were included in the local transmission plan.
And bid evaluation for the RFP, the 2022 RFP happens when?
The step 2 bid evaluation.
I believe so. Yes, the step 2 bid evaluation.
So we'll essentially begin the end of December and use updated information in April and use information from the DICES Phase 2, which we hope to receive in early May. I think that was the answer.
Thank you. So by the time you do the step 2 evaluation, you will know whether the RZEP are in the local transmission plan, correct?
I think so. I'm not sure how the timing of whether RZEP is in the transmission plan makes its way into the Phase 2 process. Since Phase 2 will already be underway in December, I'm not sure about the timing of how those two pieces merge.
Understood. But when you do the bid evaluation process, you will at least know by that point whether the RZEP are or are not in the local transmission plan?
I believe so.
And you testified that the Duke's plan as of now is to factor in the full cost allocation of any red zone upgrades into the bid evaluation process for the 2022 RFP, correct?
That's correct.
And you testified that this was driven by the commission's order in the RFP docket that the RZEP not be included in the baseline for the 2022 DICES, correct?
That's correct.
But as I believe Chair Mitchell noted, that bid evaluation is not the same as the allocation of costs in interconnection studies. Would you agree with that?
That was what I took her to mean, yes.
Okay. And in its order in the RFP docket, the commission did not tell Duke how it should go about doing bid evaluations for the 2022 RFP, correct?
I don't think that level of detail was covered.
Okay. And as I read the RFP, it lays out the multi-part bid structure that you described, but does not specify in detail how Duke is going to be considering upgrade costs in a bid evaluation. Do you agree with that?
Subject to check.
Thank you. So Duke's current plan for bid evaluation is what you've worked out with CRA at present, correct?
That's correct.
Okay. Chair Mitchell, I would ask that the commission take judicial notice of the June 17th, 2022 compliance filing by Duke in docket numbers E2 sub 1297 and E7 sub 1268. That's the RFP.
Having heard no objection, the commission will take judicial notice.
Thank you. Ms. Farber, in the RFP or with the RFP, Duke provided locational guidance to bidders, correct?
That's correct.
Okay. And if I may, and that locational guidance indicated that the red zone areas were constrained, right?
That's correct.
But in the RFP, and I apologize, I don't have a copy of it to review, but would you agree that in the RFP, Duke said in essence, the red zone is constrained. However, we are proposing upgrades to the TPC, and so the situation may change.
I'd just like to ask the chair to ask council how much longer this is going. It seems a little bit.
I do not have very much more. I am following directly on Chair Mitchell and Commissioner Hughes and Commissioner Kemmerite's questions about how the red zone upgrade evaluation fits in with the RFP evaluation. So I do not have extended lines. I'm simply trying to clarify where we stand with regard to red zone upgrades in bid evaluation for the RFP.
All right, as long as your questions are following up on questions that we asked and not continuing down.
Yes, ma'am.
Or
I am not going down any alleys, I
right.
assure you.
Go.
Subject to check, I think our final version of the RFP document did not have that statement because I believe we edited it after the commission said to not include the RZEP in the baseline.
Okay.
So I'd want to check the final filed version.
Understood. Thank you. So back to the bid evaluation process. If Duke were to, for example, come up with a different way to evaluate the cost impact of upgrades or the red zone upgrades specifically in the RFP, you would not be upsetting any settled expectations of bidders, would you?
Objection.
Sustained.
Thank you. Okay. We have been talking a lot about, and the commissioners have asked a number of questions about how the red zone upgrades could be considered in bid evaluation. Is the question of how those upgrades could be considered in bid evaluation appropriate for consideration in the RFP docket?
I think it's appropriate for discussion for a 2023 RFP. I'm not sure that it's appropriate to change the evaluation process mid-flight in the current 2022 RFP. So I think it makes sense to discuss this in planning the 23 RFP.
But Ms. Farber, you did just testify that the RFP does not really specify in detail how.
Objection. We're just way far beyond and wading deep into areas beyond commissioner questions and this proceeding's purpose.
I have two more questions, and I believe I'm squarely within the scope of a number of questions that commissioners have asked on this question of how the red zone upgrade fits in with the bid evaluation.
All right.
I understand I have a short leash, and I have
Right. And
three questions left.
Every time that we must, well, every time that there's an objection and there's a response, and then I have to rule on the objection also takes the commission's time as well. So I'm going to just ask you all one more time, all sides, please do your best. Please, you all are capable of limiting your questions to questions that the commissioners have asked. I asked you all yesterday to identify the question, the specific question to verbatim that you were responding to. I've given you some leeway and not requiring that you do that today, but for the sake of regulatory economy, we've got to get through this proceeding. And I ask you all to use your best judgment in helping us get there. And stop straying beyond commissioners' questions. All right, with that, ask your final two questions and then let's move on.
Thank you. Ms. Farber, Commissioner Hughes asked if there was a danger, I believe it was Commissioner Hughes asked if there was a danger that if depending on how bid evaluations were done in the 2022 RFP, Duke might end up picking a set of projects that are not least cost. Do you recall that?
I recall.
Okay. And it's Duke's plan, if the red zone upgrades are approved by the TPC, to designate those as contingent facilities, in which case the costs will not be allocated to individual projects. Is that correct?
I'm sorry, say that again.
I'm trying to be very quick. It's Duke's justify that it's Duke's plan to designate the red zone upgrades as contingent facilities if they're approved by the TPC. Is that correct?
In the ultimate interconnection agreement, they, I believe, would become contingent facilities if they're approved in a local transmission plan before that time.
Thank you. And in that case, the actual project would not bear the costs of those upgrades, correct?
The generator in that instance would not pay the cost of the contingent facilities.
Thank you. So last question.
No, that's 4 questions.
Would you agree that there is a danger that if bid selections in 2022 reflect the full phase 2 cost of the red zone upgrades, you could end up picking projects that are not actually lowest cost to ratepayers?
I think that We are operating the 2022 RFP under the best information we had at the time that the RFP was designed. And so we should stick with the rules and design of the RFP as it was announced to all bidders to remain fair. But this can be a consideration for future RFP cycles where the rules and specifics have not yet been determined.
All right, thank you, Ms. Farber. Thank you, Chairman, for your patience. I have no more questions.
All right, we're going to recess. We'll come back on the record at 3:20. Let's go off the record. We'll continue with questions on commissioners' questions. Who's up? Any additional questions on commissioners' questions? Okay.
No questions.
All right. I actually have one last question, and then I'll let you all go. And this is for you, Mr. Roberts, affected system costs. Have any affected system costs that would result from red zone projects, how would those be accounted for in the either in the NCTCP process or just in general?
So I'll just describe what I know about affected systems and how those costs are allocated or how they're paid. My understanding is that, for example, if a solar facility locating in Duke Energy Carolinas created an affected system in Dominion Energy South Carolina, then, and that was revealed through study that that was actually the case. We have a means for, in our study, if we see a certain level of defects associated with that solar on a neighboring facility, we'll notify the neighboring facility. If a study is performed and they say, yeah, we have an affected system, the generator pays for the affected system upgrade, and then the Dominion Energy South Carolina would reimburse the generator that amount paid for that upgrade, and they would collect it through their rates.
But I think that just from executing the red zone upgrades by themselves, doing those network upgrades, I don't think causes an affected system upgrade.
Correct.
Okay, that's, thank you for that follow-up. That was really my question is typically we do see, I mean, I understand that affected system issues would arise in the context of a generator interconnection request. And Mr. Ragsdale testified as to that when he was here. And so my curiosity was, would the actual red zone project cause any affected system costs? But you've
Yeah,
answered.
my understanding is no, by upgrading our transmission system, it's not having a negative impact. That's my understanding.
So any affected system costs coming out of the red zone would be driven by generators that are actually interconnecting on red zone projects.
Right. I believe what Mr. Ragsdale was referring to is short circuit availability to their PODs. And every 2 years, our protection and controls engineering group provides the available short circuit to their EMC PODs. And then also our transmission planners, when they evaluate a generator interconnection, if they see that that short circuit could potentially elevate that EMC POD availability, they will notify EMC.
Okay, and so then what would happen?
So if for example, their breaker KA kiloamperes rating was too low, then that breaker would need to be replaced. And to be honest with you, I'm not sure how that cost is allocated.
Okay, well, you anticipated my question. I understood Mr. Ragsdale's testimony to be that the cost causer would be responsible for that cost. And so my question is, or my concern is, if the red zone projects impact the points of delivery, I'm assuming POD is points of delivery.
That's correct.
Okay. That then the Duke utility would be responsible, and ultimately the Duke's customers would be responsible for work that's necessitated to correct the problem on the point of delivery.
Okay. And I would say with more IVRs and retiring more synchronous generation, you're going to have less fault current, not more. And so that's, I won't say all, but over time, most of their PODs should see less short circuit availability to their PODs.
Okay, so what I'm understanding your testimony to be is that given the nature of the changes or the projects you anticipate, the red zone projects, there could be fewer issues than anticipated by the EMCs or,
That are definitely not exacerbated.
okay. Okay. Did you want to, okay. All right, with that, you all, we appreciate very much your testimony today. You all may step down and be excused. And thank you for your participation in this proceeding. We will take motions.
At this time, I move that the panel's 3 exhibits be admitted into the record.
All right, hearing no objection, that motion is allowed.
Chair Mitchell, I would move that CPSA transmission panel rebuttal cross-examination exhibit 1 be moved into the record.
All right, hearing no objection to your motion, it is allowed. All right, Duke, you may call your next witnesses.
Duke Energy recalls the long lead time resources panel. And Chair Mitchell, while the panel is coming up to the stand, just 2 administrative items. There, we have just made the filing of revised version of the testimony to omit references to Total Energy's testimony because that was withdrawn from the proceeding. So that is now in the docket. I believe you all have copies and we have shared copies for folks in the room. The other item that was a carryover from the direct testimony was how we would manage to go into confidential session at the appropriate time upon questions by the parties or the commission. And we've worked that out with Avangrid's counsel as to a mechanism that would occur. It would be conducted under the standard confidentiality agreement that the parties have filed here. And at the right time, we're able to go into confidential session as
Okay,
needed.
so I understand you to mean that you all have come to an agreement on the discussion of confidential information in this hearing room?
Yes, Chair
Okay.
Mitchell, we have.
Okay, and so if we do have to go into confidential session, we'll do as we normally do, cut off we'll clear the room and we will discontinue the stream.
Thank you,
and
Chair
proceed.
Mitchell.
Okay. All right, gentlemen, let's get you sworn in. Raise your right hands, left hands on the Bible. Do you swear the testimony you're about to give should be the truth, the whole truth, and nothing but the truth? So help you God. Do we lose one of you?
Mr. Emmel's not up here.
All right, Mr. Emmel is the lucky one, huh?
Mr. Repka, with the exception of Mr. Immel, are you the same long lead time resources panel that appeared in this proceeding on September 20th, 2022 as part of the company's direct case?
Yes.
And did the panel cause to be pre-filed in this docket rebuttal testimony that now has been amended as of September 28th, 2022 that consists of 26 pages?
Yes.
And those changes or corrections that have been made today, if I were to ask you, do you have any additional changes or corrections, sir?
Yes, we have.
Mr. Repko, excuse me. The corrections that we just made, are there any additional changes or corrections?
No.
No. Okay. And if I were to ask you those questions appearing today, would you provide the same answers here today?
Yes.
And has there also been a summary prepared of the panel's rebuttal testimony?
Yes.
Chair Mitchell, we ask that the long lead resources panel corrected rebuttal testimony that was filed today and summary be entered into the record if given orally from the stand.
All right, motion is allowed.
And the panel is now available for questions from the parties and the commission on its rebuttal testimony.
Chair Mitchell, Avangrid was able to review the record from the direct, and we think that we've gotten everything that we needed this time, so we have no further questions.
In the interest of time, SIGFR is also going to waive cross of this panel. Thanks.
CC as well.
All right, CPSA,
CPSA waives cross on this panel.
Stace.
No question, Chairman.
All right, on the staff.
Chair Mitchell, I do have one question that was deferred this morning.
Okay.
Good afternoon, gentlemen. In response to a question that I asked Ms. Bateman, I believe she deferred it to your panel. So I'm just going to ask it to you. It related to CPCNs. Are there any long lead time resources for which the company does not intend to seek a CPCN or would not intend to seek a CPCN?
Directly relative to generation resources, we would file a CECPN for South Carolina for Bad Creek. Offshore wind, again, if selected by the commission, would be in federal waters. However, there would be a CPCN for the supporting transmission of it, or any supporting transmission of it.
Okay, so offshore wind, the project itself that's in federal waters would not have a CPCN, but the related projects within the confines of the state of North Carolina would.
Correct.
Thank you. Those are all the questions that I have.
All right, public staff.
Thank you, Commissioner. I would like to hand out some documents now.
Go ahead.
Thank you.
One more, please.
This is not related to, but just I'm looking for recognition.
Thank you. All right, why don't we go ahead and mark the documents?
Thank you, Chair. We have one document for the lease. The second document for extra from those February regulations. I would propose to mark these as public staff, long time resources panel, rebuttal testimony, cross-examination, exhibit numbers on.
All right, the federal regs will be identified as public staff, long lead time resources panel, rebuttal testimony, cross-examination, exhibit number 1. And the lease will be marked as public staff, long lead time resources panel, rebuttal testimony, cross-examination, exhibit 2.
Thank you. Thank you, Chair and Commissioners. Thank you, panelists, for your time today. My name is Will Freeman. I'm an attorney with the public staff. I'm representing the using and consuming public. And panelists, I would like to respectfully push back on some of the rebuttal testimony that was filed in this case. I was looking in particular on page 7, lines 10 through 12, but I think that idea sort of percolates through all of the testimony. And just while you turn, I believe it states the public staff's position, if adopted by the commission, would effectively eliminate the ability to keep offshore wind as an option to meet the 70% interim target of the carbon plan. And so I'd like to discuss some areas of respectful disagreement with respect to that testimony. I think that one area is we can agree that portfolio 3 did not select offshore wind at all. and portfolios 5 and 6 did not select offshore wind before 2040. Is that y'all's understanding as well?
That is correct. That's my understanding.
So now I'd like to talk about the other half of the portfolios that do select offshore wind in the near term, and just go head on respectfully together. The first document, I believe, was the federal regulations, and the second document was the lease. And I gave you and your attorneys a copy of the whole federal regulations, but I also just took a few paragraphs out and highlighted. So you should have both of those.
I do.
So the lease, I went to boem.gov and pulled the lease in. And you'll see on the first page of that lease in section 1, it references, about the third line down, it references 30 CFR part 858. And that is the first exhibit I gave you, a few pages from that, but then again, you have the whole part 585 right there, should you want to refer to it.
Understand.
Okay. So let's start with exhibit 1, if you don't mind. If you look on the very last page of this 4-page exhibit, which is numbered 584, and the highlighting was done by me, I'll read 585-601 with ellipses, and we'll start maybe at subsection A. Duke Wind, quote, must submit your SAP no later than 12 months from the date of the lease. Did I get that right?
It says that.
Thank you.
Excuse me. I believe
Yes.
you said must, but in the document here, it says may.
I'm sorry, I had started on the third line down of subsection A. You may submit your SAP prior, but must submit your SAP
Okay.
or your GAP no later than.
Council, may I ask, which document are you in?
I'm on the last page of exhibit 1. The number on the page is 584. I'm looking at the highlighted section A. The third line down says must submit your SAP. And that's why we're having this testimony, so we can talk about this statute and what words it uses. Mr. Pompey, are you? I'm glad to, if you'd like to look this over.
No, I got what you were saying. I apologize. I misread which line you were on.
Again, this is, this isn't an inquisition. This is for us to talk about what the law says. Subsection B on the last page of 584 uses the same word must as well. Duke Wind, quote, must submit a COP or FERC license application at least 6 months before the end of your site assessment term. Did I get everything right?
Yes.
Yes.
Okay. Let's pause on the law and then move to the lease, which is exhibit 2. And if you'll look with me on, the page number is C3. It's in section 3.1, about 3/4 of the way down on the page. I'd like to read it, but I would like to substitute the name of the parties instead of saying less or and less E. Are y'all with me? I'm not trying to rush you.
No, what section on page?
3.1, page C3 of exhibit 2.
I'm there.
Okay. Okay, again, I'm reading with substituting the name of the parties. Duke Wind must submit to the United States of America a progress report every 6 months, parentheses, unless BOEM directs otherwise, close parentheses, through the duration of the site assessment term. That includes a brief narrative of the overall progress since the last progress report, or, in the case of the first report, since the effective date. Did you see where I was, and did I read it correctly?
Yes.
Thank you so much. Now, let's pause on the law and the part I just read, and if we can go, if you'll look with me in the lease, exhibit 2, on page 1. The effective date is June 1st, 2022.
Correct.
Thank you. And if you'll look with me on page B1, the site assessment term is 5 years, and the preliminary term is 1 year.
Correct.
Okay, thank you. Excuse me, can we agree that Duke Wind must submit a progress report with a brief narrative starting on January 1st, 2023, unless Boehm says otherwise?
Only with the exception of Boehm, correct.
Okay. Can we also agree that Duke Wind must submit an SAP, that stands for Site Assessment Plan, before June 1st, 2023, unless Duke Wind asks for more time?
Correct.
And can we agree that Duke Wind must submit a COP, that's a construction operations plan, before December 1st, 2026, unless Duke Wind asks for more time?
Correct.
Okay. Now, I would like to discuss with y'all what happens if Duke Wind doesn't receive more time or doesn't comply with these obligations that we just discussed. And if we'll go back to the regulations, which I think were Exhibit 1, if you'll turn to the second page of Exhibit 1, which is page number 54564. I've highlighted it as well for ease of reference. If we can look at section 585-400B, BOEM may issue to you, and you in this case is Duke Wind, a notice of noncompliance if we, the government agency, determine that there has been a violation of the regulations in this part or any provision of your lease. Did you see where I was reading from?
I did.
Okay. And now we can come down to the section, subsection D, also highlighted. And failure of Duke Wind to address the noncompliance is the basis for a, quote, a cancellation. Correct. Subsection D, next from the last line, cancellation.
Correct.
Okay. Now, if we'll turn one more page, it's numbered page 570. This is subsection B. Again, we get back the cancellation as an option. A lease may be canceled if Duke Wind, quote, has failed to comply with, I'm going to read with ellipses, has failed to comply with these regulations or any term, condition, or stipulation contained in the lease.
Correct.
Thank you. All right, so let me talk about one more place where we discuss what can happen in the event of non-compliance. It's on section 8, exhibit 2, the lease. Section 8, page 3. Near the bottom of page 3. And I hope no one gets a paper cut. I apologize. I'm going to read again with ellipses, and I'm going to substitute the name of the parties. Section 8, page 3, and not A3, page 3. If Duke Wind fails to comply with 1, any of the applicable provisions of the Act or regulations, I'm going to skip 2, or 3, the terms of this lease, including any associated addenda, the United States of America may exercise any of the remedies that are provided under the Act and the applicable regulations, including, without limitation, the issuance of cessation of operations orders, suspension or cancellation of the lease, and/or the imposition of penalties.
Yes.
Thank you. So can we agree that if Duke Wind doesn't get more time, Duke Wind runs the risk of having the Carolina Long Bay lease canceled if it doesn't move forward with filing an SAP, a site assessment plan, or providing BOEM with progress reports every 6 months and filing a COP, construction operations plan, within 5 years?
Yes, I agree. I believe that's consistent with what we said in our direct testimony.
But Duke Wind very much wants to avoid that, doesn't it?
Objection. These gentlemen made very clear on direct that they are not part of Duke Energy Renewables Wind. Can't speak on behalf of that entity.
Hypothetically, if you had a offshore wind company, would you very much want to avoid cancellation?
I would assume it would depend on the market. You know, here's the point that we brought out in direct testimony. So agree, it says all those things. What I don't know is where is the provision for BOEM to grant extensions, because they have done so. You know, BOEM has a very limited staff. Their objective is to advance the development of offshore wind. And they were very much focused with developing leases and auctioning leases in the Northeast. They pivoted down to what is now Carolina Long Bay because of the energy exploration moratorium that was going to take place in July of this year. So it is reasonable to assume they will focus their resources back to auctions, whether it be Northeast Gulf or the West Coast, where they see a market, where they see a future market. So they have granted extensions because they really have no interest in acquiring leases back. It defeats the whole purpose of, you know, what their objective is in terms of developing offshore wind.
Well, I didn't know if you had an additional point you wanted to bring up or not.
Mr. Nolan just highlighted a section in Exhibit 1 at the very bottom of paragraph 1, top of the second paragraph that elaborates on extensions.
Extensions are absolutely permitted.
Yeah.
Okay. Does it make economic sense for an offshore wind company to spend a fair amount of money and then take no steps to develop that asset?
It would depend on where they see, if they see a future market and what that would look like.
Okay. Have you had any conversations with Duke Wind about whether it intends to seek more time to comply with these obligations we've discussed?
I have not.
Have you had any or the panel, I don't mean you, has the panel had any conversations with Duke Wind about whether it intends to move forward with the SAP before June 1st, 2023, the annual deadline?
The last information, really the only information I had, was shortly after the auction, when in a meeting there was discussion that Duke Energy Renewables Wind was procuring resources to initiate the SAP. I haven't heard anything beyond that or since then.
I think that we can agree that the time frame proposed by the panel in its testimony contemplated that Duke Energy would work on the SAP and the COP.
Are we talking about the direct testimony or the rebuttal?
Direct, I apologize.
Okay. So the time frame that was placed in the direct testimony was a time frame for the regulated utility. What we postulated would be our timeline.
And that was the 8 to 10 year timeline.
That's correct.
Part of that timeline included some time for the SAP and some time for the COP.
It did. And as I mentioned in my direct testimony, if you look at the timeline provided by BOEM, and I think you showed that here, the site assessment period is 5 years. So, you know, you mentioned 2026 December, 5 years is June 2027.
I was backing the 6 months out, but it's close,
Okay,
right?
understood.
Okay.
So Duke Energy Renewables Wind in this hypothetical situation is 5 years to submit a COP. I agree. 1 year SAP, is pretty straight, up to 5 years to submit a COP. What we were saying was that if the commission would like to have the option for offshore wind in the 2030s, in the early 2030s, that there is no obligation for Duke Energy Renewables Wind to accelerate the timeline and get a COP in 3 years, right? The requirement is 5. If we look at and you can do 5, and you can have your progress reports and be within the law and still get 5 years to do a COP. Now, aside from that, we've seen Dominion, for example, they got their lease in 2013, didn't file a COP until 2020. They worked with BOEM based on their particular situation to get an extension. Now, I don't know what Duke Energy Renewables Wind is doing, but the 5 years to get a COP would put us, I believe, behind where we would need to be if we want to get offshore wind in the 2030s.
So we can agree that if Duke Wind did move expeditiously, Duke Wind or any hypothetical offshore wind owner did move expeditiously, we would not miss out on the half of the near-term actions necessary for offshore wind to come online in portfolios 1, 2, and 4.
That's correct, but I think you make my point. If, what we are asking for, really from a directional standpoint, is from the commission that these 3 long lead resources, pump storage, SMRs, offshore wind, initiate development so that they are ready. And the proposal that we have, the solution that we have, is for the lease to go to the regulated companies, DEP specifically, to be developed with full transparency, oversight, and progress relative to the development activities that we have asked for and on the timeline that we have asked for.
Have you had discussions with Duke Wind about entering into a non-disclosure agreement and working through the details of Duke Wind taking any activities?
We have not.
Okay. Do you think let's say, study ordered by the commission would encourage Duke Wind to move expeditiously so this could be an asset available for Duke Energy in the next carbon plan?
Chair Mitchell, I'd object. It was clear in the direct testimony, and I believe also in the public staff's testimony, that this commission doesn't have jurisdiction over Duke Energy Renewables Wind as an affiliate.
Would it make sense I apologize, Chair, I didn't mean to. I'd like to rephrase my question.
All right, I'll overrule, rephrase.
Thank you. Would it make sense for a generic offshore wind company that if it received a signal from the commission that a study was forthcoming, that its asset would be more valuable if it could start on these, well, the SAP is due in a year, but start on the COP, which has the up to 5-year time frame?
It would be a consideration, but they'd have to look at the other market factors.
Okay, I understand. If I could have one moment, Chair and Commissioners. Thank you very much, panelists. Thank you very much, Chair and Commissioners. I don't have any more questions.
All right, redirect.
Thank you, Chair Mitchell. For the panel, just for clarity purposes, under the Duke Energy Renewables Wind lease, that was effective as of June 1st, 2022. When does a COP or constructions operation plan need to be submitted to BOEM? I believe you said it, Mr. Pompey, but maybe we could just be to clarify.
Yeah, that would be June of 2027, 5 years after the lease execution date.
Okay, so there was some discussion of a December 1, 2026 date. You don't agree with that date, correct?
I do not.
Okay. There was some discussion, Mr. Repko and Mr. Pompey about getting extensions from BOEM. And I believe you talked about Dominion getting an extension from BOEM to file their COP 7 years after they won the lease in auction, correct?
Correct.
Can you turn to it's public staff, long lead time, resources panel, rebuttal testimony, cross-examination, exhibit 2, page B1. B as in boy. And on the page, it is called Addendum B, lease term and financial schedule. And under lease term, where it lays out lease terms, it says the duration of each term of the lease is described below. Could you read the next sentence, Mr. Pompey?
I'm sorry, I'm not.
Oh, you're not on the same
Not
page?
there yet, yeah.
That's
It's
okay.
at Page Bravo 1?
Bravo 1.
Okay,
Are you there, sir?
I am on the page.
Okay. Top of the page, lease term.
Correct, okay.
After the sentence, the duration of each term of the lease is described below. What does that next sentence say?
The terms may be extended or otherwise modified in accordance with applicable regulations in 30 CFR Part 585.
Okay, and below then are the lease terms. These extensions and modifications are what you're talking about that Dominion took advantage of?
Correct.
Okay. And is it your understanding that those extensions are granted on a regular basis?
It is my understanding that they are, to Mr. Repko's testimony, Boehm has every intention of working with the lessee to ensure success for the lease.
Thank you. Chair Mitchell, there was also some questioning from Walmart Council about CPCN authority for Bad Creek too. And I do believe that was a question from Chair Mitchell as well about whether there was going to be authority granted from the South Carolina Commission. At the appropriate time, if you would like to ask your question again, or I can respond to it. It has a legal component to it. So just for clarity, at the right time, if it's all right with you, I would prefer to answer that question.
I was going to pose that question to the panel, so,
We can wait.
yeah, when we get there.
Thank you. I have no further redirect.
All right, questions from commissioners? Commissioner Gladfelter.
Gentlemen, I've got an arithmetic question, just to be sure I'm understanding one of your exhibits right. So with reference to the last page of your rebuttal testimony and then the figure 1 that follows that last page, you are on the last page on lines 10 through the end of the page. You're disputing Avangrid's calculus of the differential export route for the undersea cable. And you say you think the difference is that their cable would be longer by about 170 kilometers. And then I look at figure 1 and I'm trying to, there's a lot of numbers on figure 1 and a lot of different routes. Is the way I get to the 170 kilometer difference, is that by comparing the green line difference from the Carolina Long Bay to the point near Emerald Isle, and then comparing that to the blue line that moves south from the Kitty Hawk area down toward Cape Lookout Shoals and then comes in toward Emerald Isle? Is that the line I look at to compare to get a 170 kilometer difference?
Okay, I want to answer with a yes or no, but unfortunately, the one in front of me is black and white.
Oh,
So I'm gonna
Permission
I'm
to,
gonna walk through it.
permission to
thank
provide
you.
a color copy.
Oh, okay.
All right. So if you wouldn't mind walking me through the colors again.
Well, I think your counsel is going to give you
Thank you.
so you see on the figure there now, you have the color
I've
one.
got it.
And it shows that the Carolina Long Bay lease area is in green. And then there's a green line, which is the undersea cable, I assume, that goes north to a point that's roughly around Emerald Isle to the coast. And then there's the Kitty Hawk area up in orange.
Yes.
And then coming south from that, there are 2 lines, but one of them comes most directly south, then continues down over Cape Lookout Shoals and then turns inland toward Emerald Isle. And it looks to me that the difference between those 2 lines is 170 kilometers. Those are the 2 lines that are being compared in the written testimony.
That is correct. And what we
Got it.
did was we assumed, for the purposes of one-to-one comparison, that the landing spot would be the same. That way we could show exactly the delta.
I understand. It's just that there were several other possible routing combinations and I just want to be sure I was comparing the right ones to get 170 kilometers.
That's the
You've
right
answered
one.
my question. Thank you. That's all.
All right, gentlemen, do you all know whether let me start this way. Ms. Revco, I heard your testimony a moment ago that Bad Creek 2 would have to secure a CE CPCN, and that would be from which jurisdiction?
And Chair Mitchell,
Okay.
if it's all right, since it has a legal component, if I can provide.
Yep, go ahead, and then I may ask you all to file a late file exhibit, just explaining your response.
Sure. My understanding is that under South Carolina law, pardon me. Pardon me, I have the wrong section up. A hydroelectric generating facility that's regulated by the Federal Energy Regulatory Commission. If the relicensing takes place at FERC, you do not have to get a CPCN from the South Carolina Commission. However, the company could waive that requirement and seek a CPCN from the South Carolina Commission.
Okay.
So although a final decision hasn't been made yet, the company is leaning towards taking advantage of that waiver and
Okay.
seeking a CPCN before the South Carolina
Okay.
Commission, although final decision hasn't been made yet.
Ms. Link, is there is that pursuant to federal regulation?
So the relicensing of Bad Creek 2 is sort of folded into the licensing of Bad Creek 1, and it is under FERC jurisdiction.
Okay. And it's South Carolina law that no CPCN is necessary if there's relicensing or licensing ongoing at the federal levels.
Specifically for a hydroelectric generating
Specifically for
facility, which is what Bad Creek is.
Okay.
So it's a choice.
Understood. Okay. All right. Let me see if there are any other questions from commissioners. I've got questions that are going to take us into confidential session. So with that, I would ask that we clear the room. Duke, make sure you, this is going to pertain to confidential information pursuant to the Avangrid agreement. So I'm not sure how you all want to handle that, but anyone who's not privy to that agreement needs to clear the room. And I would ask that we cease the streaming and we'll go into confidential session.
That's how we forward.
Okay, we have just 3 more questions for you, Mr. Repko. Or 2 more, really. Did you, has Duke, any of the Duke entities, I'm getting a signal. Your panelists want to rejoin you? We can't find them? Oh, they've left the building. What's happening?
Good rule followers.
What's happening? They've had enough. Yeah, and can you get Mr. Eason in the room, please? Okay. Has any of the Duke entities had discussions with Total Energies about its lease?
There were initial discussions around before the lease about a potential partnership to participate in the auction. We explained the ownership provisions of House Bill 951. There were also and nothing progressed past that. There have also since been discussions about opportunities around co-development of the SAP, since it is a common geographical area, but nothing more than that.
Would co-development of the SAP save ratepayers money?
There would be savings there. The magnitudes, again, I don't have, default to Duke Energy Renewable Wind on that.
Understood.
Yeah,
But it's likely that there would be some savings.
there would be.
Okay.
Yes.
Any other opportunities to identify and realize ratepayer savings associated with the proximity of Total's lease?
Well, I mean, all of the development activities, because of the proximity, right? The meteorological wind speed, the ocean floor surveys, you get into some pretty expensive type activities. So obviously there would be cost savings associated with the sharing those.
And that's something that the sharing is an avenue the companies either have begun to explore or will explore in the future.
There are discussions, yes.
Okay.
Yes.
All right. Questions on those? Oh, I'm sorry, Commissioner Gladfelter.
Well, let me follow the chair's question on that point about the options for shared costs. Could those go so far as shared infrastructure, such as shared cabling and shared onshore facilities necessary to get to the injection point? Could those
Yeah.
be co-developed with Total?
I'd have to think about we'd have to look at that around the provisions of House Bill 951 ownership, but I'll say potentially.
I respect that, but I'm just really asking more if there were technological or physical barriers that would prevent you from talking with them about shared infrastructure.
No barriers there.
Okay. I believe we've come to the end of this panel's cross-examination.
We have no exhibits.
All right, go ahead.
We had 2 exhibits, Commissioner. I would move the public staff's long lead time resources panel rebuttal testimony, cross-examination exhibit numbers 1, which were the portion of the Code of Federal Regulations, and exhibit number 2, which was the lease, into the record and evidence.
All right, hearing no objection to your motion, it will be allowed.
Thank you.
All right, with that, you all may step down and be excused. Thank you very much for your testimony today. All right, Duke. Call your next witnesses. All right, so let's get you all sworn in, please. Raise right hands, left hand on the Bible. Do you swear testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right.
Madam Chair, this is the grid panel that has been, grid edge panel, sorry, that has been recalled. Today, Duke Energy filed a late filed exhibit at the request of the commission, late filed exhibit number 6. With the commission's permission, I can have that, I can ask the panel to introduce that exhibit and ask that it be pre-marked.
I would appreciate that. Do you have copies? Okay.
Yep. I have copies if the commission does not have copies.
I
thought
don't think we have copies.
we have copies.
Okay. Yeah. Yeah.
While they're being passed out, I could take care of some of the preliminary questions.
All right, go ahead.
Okay. Beginning with Mr. Huber. Mr. Huber, are you the same Lon Huber who appeared in this proceeding on September 16th, 2022 as part of the Grid Edge panel's direct case?
Yes.
And Mr. Duff, are you the same Timothy Duff who appeared with Mr. Huber on September 16th?
Yes.
Turning back to you, Mr. Huber, did the panel cause to be pre-filed in this docket rebuttal testimony consisting of 16 pages?
Yes.
Do you have any changes to your rebuttal testimony at this time?
No.
If I were to ask you the same questions today that appear in your pre-filed rebuttal testimony, would your answers be the same?
Yes.
Does this panel's testimony include confidential information?
No.
Did you also prepare and cause to be pre-filed a summary of the panel's rebuttal testimony?
Yes.
And did this panel, at the commission's request, prepare and cause to be filed late filed exhibit number 6?
Yes.
Do you have any changes to make at this time to late filed exhibit number 6?
No, not at this time.
Does late filed exhibit number 6 include any confidential information?
No, it does not.
Chair Mitchell, I would ask that the Grid Edge panel's rebuttal testimony be entered into the record as if given orally from the stand, and that the late filed exhibit be pre-marked.
All right, the rebuttal testimony, the pre-filed rebuttal testimony of the Grid Edge panel will be copied into the record as if delivered orally from the stand. And the late file, let's mark the late file exhibit as Grid Edge panel rebuttal. Exhibit 1.
Thank you. The panel is now available for questions from the parties and the commission.
All right, let's see, Attorney General. Okay, at voices, go ahead.
Good afternoon, Commissioners and Chair Mitchell and panel. My name is Kathy Crawley-Jones, again, here before you on behalf of Appalachian Voices. And in your rebuttal testimony, you provided some specific responses to issues raised by Appalachian Voices. I'd like to turn your attention to page 12 of your testimony, line 7.
Yes.
And there you indicated that developing new programs to more effectively target low-income customers and increase participation in their existing low-income programs is very important, correct?
Yes.
And then you go on to say that you disagree that program funding levels are a barrier to achieve this goal, correct?
Yes, the program budgets and funding are not the barrier.
So I just want to ask you a couple of questions about current programs and funding levels. Do you have a copy of the carbon plan Appendix G with you?
Let me see. Yes, I do.
If you please would turn to pages 28 and 29.
I'm there.
And figures G6 and G7 generally shows summer and winter demands and peaks, and then discusses the higher peak load typically generated by low-income customers. Is that fair?
Subject to check. I don't have time to read it. I do see that
That's-
it calls out the different load shapes.
Okay, and then specifically looking at the very last sentence at the bottom of page 28, you'd agree with that conclusion, wouldn't you, that the partnership and engagement with low-income customers and advocacy groups will be critical for addressing this load?
Yes, we've long thought that, and we've long engaged with the low-income community weatherization agencies, as well as other broad stakeholder groups that are interested in representing the interests of low-income customers.
And so now, if you would, turn back to page 6 of that, where you list in table D1 all of the current residential energy efficiency programs.
Almost there. Sorry about that.
No worries. Page 6.
I have a
There-
copy.
Okay, there it is. Yep, I see it.
Okay. And there you've got listed the residential programs. And focusing on low income or income qualified programs, the only targeted program listed in that table is the low income weatherization program, correct?
No, there are two programs that are specifically targeted at reaching low-income customers and income qualified customers. The Neighborhood Energy Saver Program and the Low-Income Weatherization Program. But as we talked about during my direct testimony, many of our mass market programs also effectively reach those customers.
But the Neighborhood Energy Saver Program, that is not limited to income qualified customers, correct?
Yes and no. It targets income qualified customers because it targets neighborhoods where greater than 50% of the homes in that neighborhood or geographic area are at or below 200% of the federal poverty guideline.
Remind me, I think that program though doesn't include all residential customers, correct? Doesn't it exclude mobile homes?
It currently does not, I believe, allow those manufactured homes. That's correct.
And does it also exclude rental homes?
I don't believe it excludes rental premises because it can cover multifamily rental premises.
But if a person rents their home, unless the owner agrees, that's not a program open to renters.
Yes, we can't make modifications to a customer's home without the owner of the residence agreeing to those modifications.
Now, you talked about modifications under the Neighborhood Energy Saver Program. I've seen on the website that that's listed as $180 value. Does that sound correct?
So I think you're talking about the Tier 1 program in terms of the measures that are directly installed according to the program. But unfortunately, during COVID, right before COVID, we had implemented a change to that program to include much greater valued measures and deeper energy efficiency saving measures. And it was targeting at participants in the low-income neighborhood energy saver program that had higher energy usage. So if they had higher energy usage, they would qualify for more expensive measures. But with respect to the $180, that was the value associated with the direct install measures that were under the original tier. Like I said, unfortunately, because of COVID, we haven't had a ton of opportunity to get participation in that because we have seen a real barrier to getting into customers' homes because of concern about the pandemic.
The website indicates that there's $30 worth of free stuff. Do you disagree?
So I think when you say free stuff, I think you're talking about the measures of value versus the person going in and installing and auditing the premise.
And that stuff includes LED bulbs?
There were some specialty LED bulbs, I believe, still included in that program, yes.
And a low flow shower head?
I believe that's one of the measures, yes.
And then switch and outlet seals?
I think that's correct, yes.
Okay, for a moment then, let's go back and focus on the program that is listed here as low-income weatherization. Taking a cue from Commissioner Clodfelter during your direct testimony, I checked out the Duke website and wanted to take a minute to talk about that program. It appears, based upon the website information, that the program is conducted in partnership with the North Carolina Community Action Association, correct?
That's correct.
In fact, the Duke website refers inquiries to the NCCAA website to determine eligibility, correct?
That's correct. They help it to administer the program.
Do you know what the current funding is for that program and how many low-income customers it serves?
I can't tell you how many have participated this year or what has been spent this year. I can tell you that I do recognize there have been some challenges, again, getting participation in that program. Again, due to workforce issues, finding the actual labor to do it. But that's not unique to that program. We've struggled with other programs to get the necessary workforce to do the energy efficiency audits for some of the other programs and get into customers' homes. And I also think it's important to note that the supply chain issues and the availability of equipment have also impacted that program, has been what I've been told. So yes, I think our participation is lower than what was originally projected. But I think that's been something that we've been dealing with in the post-COVID world across not only our Neighborhood Energy Saver low-income weatherization program, but all the other programs.
It's late in the afternoon and I'm trying to ask pretty direct questions. So would you agree with me, or do you have any reason to disagree with the information on the website that says approximately 5 million will be provided annually for this program and over 1,600 customers are expected to participate?
That's I believe the targets, yes.
And that program is only available in the DEC territory, correct?
As I discussed with you, specifically in my direct testimony, we filed for the expansion of that program in June to the DEP service territory. But yes, it is currently only available in DC.
Thank you. And we discussed earlier during your direct testimony and the App Voices Exhibit 3 that DEC has approximately 580,000 low-income customers. Would you accept that subject to check? That was that.
Subject to check.
Okay. So if 1% of DEC low-income customers participated in the weatherization program, that would be 5,800 customers. Does that lawyer math make sense to you?
Yeah, and subject to check. I think that's pretty accurate.
But the website says that there's only 1,600 that were expected to participate in the program. So under the existing program, that would be less than 1/3 of 1%, correct?
So that I think your math is correct. I think it's important to note, though, that a lot of the limitations on participation are not associated with the funding that you referenced. It's due to what we can get done through the actions agencies and that collaboration.
We can disagree about the reasons for it, but question for you, is reaching less than 0.3% of low-income customers for weatherization, is that a target that Duke's satisfied with?
It's a target that we believe was accurate at the time it was put on the website. We have been working with the Low Income and Affordability Collaborative, including stakeholders like App Voices, to try and identify ways to improve the effectiveness and the reach of those programs. But as I said, some of the program administration issues associated with that are not directly within Duke's control.
And you mentioned before that you've applied to expand that program to DEP. Will that 0.3% be a target that Duke would find acceptable in the DEP area as well?
I can't speak to what percentage it is without having the numbers in front of me. I can tell you we tried to put in realistic projections with respect to knowing what's going on in the market and knowing the issues we've seen with the DEC program, the participation that we think we can accurately get. Again, to inflate projections would only serve to artificially increase the rider without justification.
And I guess whether it's projections and rider or if it's a target, a program goal. And I think that was my question, is that an acceptable target for Duke? Point.
So I don't think you can delineate the two. We use the program budgets, but as I mentioned, really, I tried to mention a number of times, the company is not capped by its targets or its budgets that it puts in its rider filing. Those we use for planning purposes, for cost recovery purposes, to try and let people know what we think we can achieve. It's not a cap. We're not trying to leave low income impacts on the table. If we can get the participation, given some of the constraints that I've talked about, the company would love to get the participation. It's not a matter of the budget providing a cap on what can be done or the target being a cap. We're putting that out there to communicate what realistically we think can be done, as well as make sure that what we're seeking in cost recovery is appropriate and not inflated.
Table G1 list, we've talked about the low-income weatherization program, but it doesn't include other targeted low-income programs, but the Helping Home Fund is another program listed on the Duke webpage when you search income qualified services. Is the Helping Home Fund a program, an existing program in the DEP service area?
I don't believe it is, but the Helping Home Fund is not an energy efficiency program. So I'm going to be limited in what I can talk to about the Helping Home Fund. The Helping Home Fund is not something that is a part of the commission approved EE monies. So it's outside of the scope of really what I can testify to.
Okay. Well, let me offer the website description of it and see if you disagree. The website says,
Objection. I believe that Mr. Duff has explained that he is not knowledgeable about this. The Helping Home Fund is not part of our EE portfolio. It is funded through shareholder dollars and has been the result of mergers and rate cases in the past. It is not within the purview of Mr. Duff's rebuttal testimony.
It's probably Jones.
Commissioner Clodfelter, I believe, had asked about if I wanted to find where these low-income programs were, where would I look on the website? I checked the website. The website says income qualified services, and that includes the Helping Home Fund, which the website describes as income qualified North Carolina families will save energy and money through free home energy makeovers provided by Duke's Energy's Helping Home Fund. Households will receive energy saving upgrades through a $2.5 million.
All right, Ms. Crawley Jones, what's your question though? I mean, why are you asking this witness the question?
Again, to see kind of the targets of who is being reached by these programs.
Okay, I'm going to sustain the objection because Mr. Duff has indicated that that particular program is not within the scope of the programs that with which he's familiar.
Okay.
Madam Chair, just so the record is clear, the question I asked Mr. Duff was not about low-income programs. It was about the integrated grid solution retail products.
All right. Please proceed, Ms. Crawley Jones.
So on page 9 and 10 of the Exhibit G that we've talked about, the company lists the planned and proposed EE programs. And in your rebuttal testimony, and you've said today that those program funding levels are not a barrier to reaching the shared goal of more targeted investments for low-income customers and increase their participation. And based upon what we've talked about, we've got a current allocation of $5 million for the weatherization fund. Is that an annual allocation fund?
So I think it's the projected annual budget associated with the program that's approved.
Okay. And has Duke determined how many more customers in at least DE C would fall into the 200% to 300% range of low-income customers?
We didn't do that analysis specifically. The issue with that analysis is it fluctuates. It's a point in time, and so it's a little bit of a challenge to do that, as well as it's tied to residents, and residence changes over time. But it's something that we can do at a point in time, but we did not do that specific analysis.
And I would assume then that you haven't done the analysis for DEP to figure out how many additional low-income customers would be included in that mix if the goal were expanded to 300,000.
No, as I said before, the proposal to potentially increase the income qualification for certain new low-income programs would just expand that pool of customers that would be eligible for low-income programs. As I said, that with those income qualified programs, obviously we would want to make that eligibility change as part of a program filing, and we would have participation projections at the time that we would be seeking approval of that, as well as the cost effectiveness, which, as I mentioned before, is something we'd want the commission to consider, since income qualified programs tend not to be cost effective.
Have the companies considered just setting a goal for energy efficiency programs designed for and delivered to low-income customers as part of shrinking the challenge, just saying we will reach X percentage as a goal?
We don't think that that's necessarily an accurate approach to do things. Like I said, income qualifications can change that would qualify customers as eligibility. And as I also talked about before, it's important to remember that we have a whole portfolio of programs that can help those customers achieve savings. And so to put specific targets associated with a segment of customers is something that would likely be somewhat of a distraction from the overall goal, which is to get as much cost-effective energy efficiency, and in the case of the carbon plan and factoring in income qualified programs, as much energy efficiency as possible. We don't think you need a target, because the target is to do as much as we can.
We talked earlier about the American Council for Energy Efficient Economy and their scorecard and where DEC and DEP fell into that scorecard. And I haven't had a chance to review in detail, but it appears that part of your late file test exhibit goes into some explanation about that. Can we agree that there are utilities and regulatory bodies in other states that have implemented program goals and funding requirements that target energy efficiency programs for low-income customers?
I'm not specifically aware of any. None of the states that Duke operates in that I'm familiar with, we don't have those specific targets associated with achievements, other than what we have here in North Carolina, which is a projected target as a part of the cost recovery filing, and then annual reconciliations to that target.
In follow-up to your direct testimony, Commissioner McKissick, and I really did find this one in the transcript, asked whether you could, quote, discreetly identify what set of policies would really need to be adopted and what set of circumstances would be needed to get there. And that was, if needed for the record, on page 73 from the September 16th hearing. Do you recall that exchange?
Yes, I do, because that was on the 16th, as you said. That was the cause for the late filed exhibit that I thought was going to take a lot more time, and I thought I had 30 days and found out I had 11. So yes, I definitely remember that conversation.
Are you aware that ACE, the group that we've talked about before, has put together a guide for regulators supporting low-income energy efficiency?
Not specifically, no.
Okay.
All right, Ms. Crawley-Jones, I'm going to stop you there. We've come to the end of the day. We will be back in the morning. Let's go off the record. We'll be back in the morning at 9:30 And we'll resume with Ms. Crawley Jones's examination of the panel.